The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Welcome to the Appeals Court. I'm Judge Milkey. With me are my colleagues, Judge Lemire and Judge Singh. And we are your panel for 5 out of the 6 cases today. Judge Henry is joining us for the second case. Where the first case of the day is Commonwealth versus Bailey. That's 2019 P 1836. I would just remind counsel that we have read the brief, so we are familiar with both the facts and the arguments. So to the extent possible, I would urge you both to cut to the chase. And with that, I will turn the floor over to Attorney O'Meara Costello.
Thank you. Thank you, Your Honor. Good morning. So I want to start by discussing the sufficiency of the evidence as to Mr. Bailey's conviction for leaving the scene. As you all know from the briefs, there were 2 accidents here that 3 officers testified to having witnessed the first accident on Quincy Street, and that the defendant then continued after striking the bumper of another car for several more blocks, made a turn, made another turn, and then they lost sight of him and found the car at a stop. They later discovered damage to another car on that street. And so he was charged with leaving both accidents. The indictment speaks of both the Honda Accord that he allegedly struck on Quincy Street and the Acura that he allegedly struck on Adams Street. And for different reasons, there are problems with each of those allegations. And, you know, as an initial matter, there's no specific unanimity instruction here. There's no special jury verdict slip. And so the jury was just presented in a single count with both of those incidents. And he was charged with leaving both of those scenes.
Should we view them as one continuous accident?
So you shouldn't, because they're separated by a fair amount of distance. They're separated by some amount of time. We don't know exactly how much time. One of the officers testified that it was in the neighborhood of 5 minutes that they were pursuing the car. And, you know, as to the first accident, what I'm arguing is that there was insufficient proof of damage to the car, but there certainly was proof that he left the accident, that he continued driving, and that he drove for several streets after that point. So from Quincy Street to Percival or Bowdoin Street, and then on to Adams Street. So it's
wouldn't the Commonwealth be required, the way it was indicted, to prove both? In other words, the specific unanimity charge wouldn't gain anything because they have to prove both, don't they?
I think they do have to prove both. You know, I think that the court would reach the specific unanimity issue only if you found that there was sufficient evidence as to each accident. So I'm obviously primarily arguing that there was sufficient evidence as to neither accident. But if either accident is not proven such that a fact finder could find beyond a reasonable doubt that all the elements were met, then I think that the conviction on that count has to be vacated.
So if we were to find there was sufficient say in the first accident and not sufficient in the second, your position would be specific unanimity would have been required?
So yes, I think my position is that where there are 2 different incidents, they're charged together in one count. They could, I think, have been charged separately. I think that they also could have been, you know, the Commonwealth could have, or either party could have asked for a specific unanimity instruction and a separate verdict slip. And at that point, if the court found that there was sufficient evidence as to the first accident on Quincy Street, but not as to the second incident, then it would be clear what the jury had found, and it would be clear if the jury had found.
But if we were to conclude that there was sufficient evidence as to both, then wouldn't the jury have understood that the Commonwealth had to prove both, and therefore there couldn't be a specific unanimity problem.
Well, I don't know if the jury would have necessarily understood that, but I also think the problem is not just would the jury have understood that the Commonwealth had to prove both, but also would the jury have understood that they all had to agree on which. I mean, I think that they're not given any instruction to the effect that, they're given an instruction that as to each charge, because there's both the leaving the scene and also a reckless operation charge here, that they have to be unanimous as to both counts, but they're not given any specific instruction saying, in order to find Mr. Bailey guilty of leaving the scene, you have to find that he left both of these accident scenes. So, as to that, thinking about the first scene, one thing that I want to make sure that I address is that, these are cars that are going very fast, or this is at least Mr. Bailey's car is, according to the officer's testimony, going fast. This is not a case where he's allegedly hitting an object that's not moving, or that is, or where he's smashing into the side of a car. It's based on the officer's testimony, he goes around a car that's in motion and clips its bumper. And then there's no testimony, there's no photographs, there's nothing to say what actually happens to that car. There's nothing to prove damage. As to the Adams Street collision, the officers pull up and he's stopped. And there's no suggestion that he leaves his vehicle and tries to leave the scene on foot. He's 3 or 4 car lengths away from the car that they think he hit, which is, I'm obviously not going to offer scientific testimony, but it takes some time to stop, even if you're going at a high rate of speed. I can't imagine that it would take less than 3 or 4 car lengths to stop at following an accident at the speed that the officers testified that he was going. And there's nothing to suggest either that he refused to make known his name, his registration, and his address, which is the statutory information. On the contrary, it appears that he did make that known because there's a ticket that the officers fill out that has all of that information on it. And so there, he just hasn't left the scene. There's also nothing to definitively say that he hit the car that they believe he hit. There's damage to his car, there's damage to that car, but no one sees the accident. And again, there's no photographs of either the Volvo that the defendant was driving or the other car, the Acura that they believed was involved in the accident. One thing that the Commonwealth's brief suggests is that there's a suggestion in the Commonwealth's brief that there's debris on the street between the Acura and the Volvo. And so I want to be clear about what's actually in the transcript on that. The transcript just says there's debris from the Volvo's bumper. It doesn't say where it's located. It definitely doesn't say that it's between the Acura and the Volvo or that it's near the Acura. And so there's really nothing to connect these vehicles except the damage on them. And without photos of that, I don't think the jury was in any position to make a conclusion beyond a reasonable doubt that the damage was because they had collided with each other.
Can I just take you back to the, I understand your point on this one regarding no one having actually seen the collision, but also your point about the defendant walking away, leaving, in absence of that kind of information. On the first one, you indicated that there was no information regarding the damage. There was in the tape, though. Is that right? In the recording, there was some information about the damage?
So what the recording has in it is the dispatcher is talking to one of the officers, and he says to one, and there's back and forth about, that there was an accident and that there's a damaged car on Bellevue Street, and is that related or unrelated to their situation with Mr. Bailey? And the dispatcher at some point says that Bellevue Street car, that's going to be related to this. The suspect's vehicle did damage that other car. So it's not a lot of information, first of all. I don't think, and the standard is not just that there's some record evidence to suggest damage. It has to be that a reasonable fact finder could find beyond a reasonable doubt that it was damaged. But also, of course, that's not, it's hearsay within hearsay. It was specifically objected to by defense counsel. And so I've also raised in my brief that that the tape should never have been admitted in its entirety, and certainly that portion of the tape specifically, defense counsel objected to repeatedly.
But even if we disagree with you and say that the tape did properly come in, you're saying even then, the jury could not have relied on that information.
Yes. So I'm saying,
just to be precise, though, I mean, as I understand it, tell me if I'm wrong, defense counsel put the tape in. So the issue isn't whether it could be admitted, it's whether it had then to be stricken after it came into evidence.
so I think there was a misunderstanding. I mean, you could see pretty clearly in the transcript, there's a misunderstanding at trial where defense counsel plays, if you look at the tape, it's all these sort of little blocks and then space in between them. And so he plays a couple of these little blocks for the jury, and then he does move the tape into evidence. And then the prosecutor starts to play the tape. And as soon as that happens, defense counsel objects and says, well, I understood that I was only moving into evidence the specific clips that I was playing. And the judge and prosecutor take the position that the whole thing is now in evidence. And defense counsel objects. There's a lot of discussion back and forth on the record about how to handle the tape and how to handle information that's irrelevant on the tape. And so I think that it's an understandable mistake. I think defense counsel also explains that in past trials, what's been done is not that the entire turret tape is given to the jury, but that people admit specific portions. And if the jury then wants to hear.
Yeah, but wasn't the jury instructed then about the relevant portion of the tape?
So the jury was given a piece of paper that contained a description of how to play the tape, first of all, because you have to use the special software. And so it's not like they just get a CD. And then at the bottom of that, it said something along the lines of that the parties have designated a time frame of 1 hour within it, which basically spans the time from when the pursuit of Mr. Bailey's car begins and they get on the radio about it until the time when, the firearm is located and the vehicle is towed and everything is completely done in terms of the incident as a whole. Within that time frame is the information that Justice Singh referred to that's on the tape about saying, oh, there was damage with the dispatcher saying there was damage to this car, which is hearsay presumably based on something that the owner of the car is saying to him. There's also a lot else that's irrelevant, but there is a note saying that this is the time frame. At some points in the transcript, defense counsel suggests that what you could do, and I think this would have gone a lot farther towards solving the problem, is say, these are the clips that we played in court. You could certainly designate like the clips that start at these timestamps are the ones that are relevant to this case and are the ones that are played in court, rather than encouraging the jury to listen to the entirety of this hour-long segment, which again, there's a lot that's irrelevant in that span. And there's also this hearsay within hearsay that defense counsel specifically preserves the objection about. And so I don't think that was, I'm sorry, go ahead.
Well, is there anything on the record that indicates the jury heard all of that?
So there's nothing in the record to suggest what the jury did or didn't listen to. The prosecutor in his closing encouraged the jury to listen to the tape. He said several times, listen to the tape. And he also specifically directed them to the part of the tape concerning the owner of the Honda Accord on Quincy Street that was allegedly damaged. And so he did actually specifically draw their attention to the hearsay that's most damaging and most inadmissible on that tape. But of course, we can't know what the jury did or didn't listen to, and they would have had the entire 3-hour tape in their possession. So if there are no further questions, then I would rest on my brief.
Seeing none, thank you very much. We will now hear from the Commonwealth.
Thank you.
Thank you. Good morning, Your Honor. May it please the court. Ian McLean on behalf of the Commonwealth. This court should affirm the defendant's convictions in this case. I will start right where opposing counsel left off with the defendant's own exhibit, Exhibit 8. Justice Milkey, I believe you were asking about the instruction to the jury about how to play the tape. You can find that at defense appendix, page 112. It was just a written instruction that was provided along with all of the exhibits to the jury. It was not spoken to the jury during the final charge. And I'll tell you what there are 8 numbered sentences in that written instruction, and they address how to play this tape. The turret tapes can be complicated to play. The 7th instruction reads, it's just one sentence, and it reads as follows. Time frame 1044 to 1144, and the recording bars contained in that span have been designated by the parties as in reference to this case. So that was the material they were given about how to play this tape and what portion of it was relevant to this case. The defendant complains of references during the turret tape to 3 separate unrelated sort of incidents, one involving a potential stabbing, one involving a fight with a series of high school kids, and one involving potential drug sales. So the first thing, and I think the most important thing to take away in this claim is that it is the defendant's exhibit. So we are talking about an invited error. So it would be reviewed for a substantial risk of a miscarriage of justice. And there simply wasn't any prejudice here. The jury acquitted the defendant of all of the firearms charges. So if they had been overborne somehow by references to what from the turret tape is clearly an unrelated stabbing, a fight involving high school students and drug sales, it didn't influence them in any way because they returned not guilties on the top charges.
You think it's invited error, even though the defense attorney made it very clear shortly after the introduction of that turret tape that they only wanted a specific portion to be admitted?
Yes, Your Honor. To introduce an exhibit that requires redactions, you simply say de bene, and then everyone understands that this exhibit will be subject to redactions. That would not happen here. The defense attorney moved the entire tape into evidence, and it was received into evidence. The trial judge was absolutely correct in his or her, I'm sorry, I don't remember who the judge was, in their approach. Your Honor, even if you disagreed with me that it was invited error, then this error was waived. The defendant acknowledged that he was satisfied with all of the exhibits before they went back to the jury. So even if it wasn't an invited error, it was a waived error, same standard of review. But even if you disagreed with me there and said there was an objection here, then the objection was vague. They didn't specify in any of the series of complaints about the turret tape what portion of it he was objecting to as hearsay. So that's a general vague objection.
But everyone agrees that there were portions of the recording that were completely irrelevant to this incident. Everyone agrees on that.
Yeah, yes, Your Honor.
So why would it make any sense that defense counsel was seeking to introduce these wholly irrelevant portions of the recording?
Well, first off, Your Honor, except he did. He introduced the whole CD. Second, when he objected to portions of his own exhibit, he didn't specify what portions of his own exhibit it was. So you have a trial judge in a situation where a defense attorney is saying, let me change it from a CD to photos or a video, and he's introduced a 2-hour video and said, objection to the video, it's not relevant except for the parts that I played. That doesn't help the judge identify what the actual objection is to what portion of the tape. So I'd say it's not even a preserved objection. But even if you disagreed with me there, even if you were to characterize this as a preserved objection to his own exhibit on the grounds of hearsay, then it was still admissible. The defendant had spent his entire case challenging the police officer's actions, which is challenging the legitimacy of their investigation. And so that's a Bowden defense. So that opens the door to hearsay being admissible for the officers to explain their investigation. So that's why the whole thing was admissible anyways. But ultimately, the point is,
how did the references to the stabbing, et cetera, help the Commonwealth with its Bowden defense? I mean, opposing the Bowden defense. It
puts the investigation in the proper context of what was going on in the community at the time, that there were multiple events going on at the same time. It was a chaotic environment, and these officers were making split-second decisions to pursue this defendant as he engaged in a high-speed flight through the community. That's all, Your Honor.
Do either of my colleagues have any questions on this part of the case to return to sufficiency? Why don't we turn to the sufficiency? And could you start, I take it from your brief that you agree with the defendant that the way this was pled, the Commonwealth has to prove both.
Yes, Your Honor, it was pled in the conjunctive, and both vehicles were specified by the owner of the vehicle. So the Commonwealth had to prove both.
Were we hypothetically to conclude that there was insufficient evidence as to one but not both of the incidents, then under your theory, I take it, we would have to order that a judgment of acquittal enter as opposed to a retrial.
No, Your Honor. So normally in a sufficiency case, yes. The pleading it in the conjunctive means that the jury, in order to convict him, they found both incidents occurred. So they have unanimously found both incidents occurred, and that negates the need for a specific unanimity instruction.
Because I'm not talking about specific unanimity. I'm saying that isn't a necessary ramification of your agreeing that the way it was pled, the Commonwealth had to prove both, that if you are unable to prove both, isn't the evidence therefore insufficient, and therefore a judgment of acquittal would be the relevant remedy?
Respectfully, no, Your Honor, because either of the two incidents could have stood alone. They could have been charged, one or the other could have been the charge without a reference to the second vehicle at all. So if the jury came back guilty here on both of them, and this court were to determine there was insufficient evidence on one of them, we still know that the jury came back guilty on the other one. So if there was sufficient evidence on the other charge, then there's still sufficient evidence to support the overall charge. It would be like the Commonwealth in an ABDW case had pled the specific weapon. They added additional things into their charge, and it's essentially rendered superfluous. It's not legally necessary to support the conviction. So here, either of the two incidents, either of the two vehicle collisions would have sufficed to establish all of the necessary elements to convict the defendant. So here, because we put two collisions together in the same charging instrument, the jury came back guilty. That means we know that the jury found all of the elements for both of the two collision incidents. If one of the collision incidents, we failed to prove one of the elements, we still proved all of the elements necessary regarding the other collision instrument, so the conviction is still supportable. So turning to the two individual events itself, beginning with the collision with the Acura, beginning with the collision with the Acura on Adams Street, the second collision, the defendant seems to challenge two elements there. First, that the collision occurred at all, and second, that the defendant actually left without providing his information. Regarding the collision occurring at all, as we all know, circumstantial evidence alone with reasonable inferences can support a finding, support a conviction. So here we have a high-speed pursuit at 50 miles an hour. The defendant makes two quick turns, leaves the officers who are pursuing him's view for a brief moment. They are then able to see him again, and the vehicle is now stopped in the middle of the road. And if you compare the description to the damage done to the two vehicles, the parked Acura had damage on the driver's side front quarter panel and front fender. That's at 230/35 and volume 4/23. And that was consistent with the extensive damage to the Volvo, the defendant's front driver's side bumper. And you can find that at 236/131, volume 4/20, page 21. So as he came around that corner onto Adams Street at an excessive rate of speed, he took the corner wide, and on the front driver's side portion of his car, he struck the parked Acura that was there. And we know this because there was debris from the defendant's car near his vehicle, and he was about 4 car lengths down the road with a broken axle leaving the front of his car on the road. Because he had just been engaged in a 50+ mile an hour high-speed pursuit, we know he clearly didn't have a broken front axle. So from all of that information together, you can infer that the broken front axle just occurred. From the damage to the both vehicles being consistent with the collision having just occurred, it's reasonable to infer that this defendant was... Yes.
Counsel, how about turning to the hard issue, the leaving the scene? If you're 3 or 4 car lengths from the accident, how can that be considered leaving the scene of an accident?
The impossibility of your well, two things, Your Honor. First, I'd say that's a jury question. That goes to the jury to determine if the defendant was actually leaving the scene. Second, I'd point you to the Matthews case that opposing counsel cited, where there the defendant was unable to leave the scene because pedestrians in the immediate area surrounded her and prevented her from leaving. So her impossibility didn't thwart that she was leaving the scene. There is no strict measurement of the number of feet required to actually leave the scene. So here, because the defendant's vehicle was so badly damaged that he was only able to make it 4 additional car lengths, doesn't thwart that he was leaving the scene. The jury was also aware that he had previously hit another car and not stopped and was continuing his high-speed flight from police officers. So here, the fact that he only made it 4 car lengths, whatever distance that is, 60 feet possibly, is of no consequence, especially when we evaluate that this is a sufficiency claim. So we review the evidence in the light most favorable to the Commonwealth. We draw all reasonable and possible inferences in favor of the Commonwealth.
Okay, but counsel, why, I mean, all the evidence you just cited seems to be evidence of an intent to leave the scene. If the circumstances prevented him from leaving the scene, why isn't it something akin to an attempt to leave the scene of an accident that he had not yet accomplished?
Well, Your Honor, I disagree with your interpretation there because he did leave the scene. The statute doesn't impose any number of feet you have to leave the scene by. If you hit a car right outside your house and then you walk inside your house and that's only 15 feet away, you've still left the scene.
But what if it was the impact of the accident that caused him to be a few car lengths ahead? It was simply the impact of the accident, nothing volitional.
Well, Your Honor, that would be reviewing the evidence not in the light most favorable to the Commonwealth. And as this is a sufficiency claim, we have to view the evidence in the light most favorable to the Commonwealth and draw all reasonable and possible inferences.
But is
in
that
the
a
Commonwealth's
reasonable?
favor.
Is that a reasonable inference? Isn't this actually one of those areas where it's not possible to draw an inference in one manner or the other?
No, Your Honor. In light of everything that led up to this moment, that the defendant was engaged in a multi-minute, it's unclear if it was 3 to 5 minute high-speed flight from police officers, had previously hit another car and kept going, and now makes it around, runs a red light and makes it around 2 quick turns, and the officers briefly lose sight of him. He hits another car and goes as far as he can. That's still leaving the scene. There's no evidence at all that he made any efforts to return and provide the information to provide his contact information to the person whose vehicle he had just decimated.
Counsel, I haven't done the math yet either, but it is possible to do the math. And if you're going that speed, I don't know, it's something on the order of a second between the accident and the 50 or so feet that you got beyond the accident. How can stopping 50 or so feet from the scene of an accident in a second or two, as a matter of law, be leaving the scene of an accident?
Well, Your Honor, you've crafted several things into the record that are not there, and respectfully, that's no longer reading the facts in the light most favorable to the Commonwealth. The testimony was that the vehicle was out of the officer's view for about 5 to 10 seconds. So it wasn't 1 second, 5 to 10 seconds. Second, you've assumed that the collision happened at 50 miles an hour, and you've assumed that that collision carried enough momentum after the impact that he was only able to go what you're assuming is 50 feet. So there's a series of assumptions there, and respectfully, that is not looking at the evidence in the light most favorable to the Commonwealth. Here, there was no evidence about how fast he was actually going. There was no evidence about how much of his momentum was lost in the collision. The only evidence is that he had significant damage to his vehicle and a broken axle, and he was 3 to 4 car lengths away. So when you evaluate that evidence in the light most favorable to the Commonwealth, as one must,
Except
that's enough.
under Lattimore, you still can't speculate. And aren't you filling in a bunch of evidence that takes the...
No, Your Honor. What I'm saying is he made it 4 car lengths away, and that's as far as he was able to make it. And I'd point you to the Matthews case where the defendant was only able to make it a few feet away before she was stopped by people, and that was enough for leaving the scene. Here, it's exactly the same situation.
Wasn't there affirmative evidence in that case that that person was making an attempt to leave? And what?
Well, you've inferred now that her intent was to leave. She was walking away from the actual immediate situs of where the collision occurred. Just as here, he drove as far away from the immediate situs of where the collision occurred as his vehicle was capable of going. There was no evidence that she was providing her information to the owner of the vehicle she struck, just as here, no evidence that that the defendant made any efforts to provide the information to the owner of the vehicle he struck.
Quite a significant difference if somebody can actually get out of their car and walk away, and the other person can't get out of their car. So you don't know that they're actually on their own stepping away from the incident, as opposed to simply landing there as a result of the accident.
This is again looking at the evidence not in the light most favorable to the Commonwealth. The driver's side door was inoperable. There was no testimony about the passenger side door and no testimony about the windows at all. Turning to the other collision, either one of these collisions would be sufficient on their own to support the conviction. And respectfully, the turret tape counts in the sufficiency analysis of the initial collision because it was admitted into evidence. Even improperly admitted evidence factors into the sufficiency analysis. And I see that I'm out of time.
Counsel, unless my colleagues have questions, I think.
Just one more.
Oh, yes.
With respect to the earlier accident or the earlier collision, one of the elements is that the defendant must be aware that he's caused damage or that there's a collision and he continued to go. Is that right?
Correct, Your Honor.
Okay. It was described, I think, as in some places as him just nipping another car while driving by. So wouldn't we have to have some more information about the real nature of the damage, or some more details about the nature of the accident to ensure that he would have understood that he actually collided with somebody?
So, Your Honor, we're talking about intent, which is something that's always inferred from the circumstantial evidence. And the word that you use, nipping, I don't remember that being anywhere in the transcript at all. What I have is at volume 2, page 33, hitting the vehicle. At volume 2, page 34, hit the Honda. And at volume 2, page 35, did not slow down. And then on the turret tape, the victim's description of what happened, he crashed into my car. So I think you take those three things together, and from those three things, combined with the fact that the flight, he was traveling at double the speed limit on the road, he was weaving in and out of traffic, including crossing the double yellow line into oncoming traffic to evade the officers. I don't think there's any basis on which you can infer he was not aware that he had just struck another vehicle. If he hit him hard enough to where the victim described it as he crashed into my car.
Counsel, thank you both very much. Excellent job on both sides, and the case is
Case is now being recorded.
thank you both very much. We are back on the record with a slight change of panel, now joined by Judge Henry. The next case we are hearing is 2020 P530, Commonwealth versus George Mackey. It is a partially impounded case. If you hear counsel referring to victims by name, we have agreed on the use of pseudonyms. I just want to remind the parties, we have read the briefs, so we are familiar with both the facts and the arguments. So to the extent possible, I would urge both counsel to cut to the chase. And with that, I will turn the floor over to Attorney Day.
Thank you, Your Honor, and good morning. May it please the court, my name is John Day. I'm the attorney for the appellant George Mackey in this matter, and Mr. Mackey was a respondent in the underlying Section 12 SDP petition. As laid out in more detail in the brief that I filed on behalf of Mr. Mackey, this is a case in which a series of errors cumulatively deprived him of a fair trial. And what I mean by that is any one of these errors raised concerns, but all taken together, as I'll lay out a little more detail here, and I tried to express in my brief, cumulatively combined to deprive Mr. Mackey of a fair trial for two reasons. One, there was a host of information that was presented to the jury that was not admissible, even under the Chapter 123A standard and statute. And there was the Commonwealth did not meet its burden of proof because it only had one witness to testify that Mr. Mackey was sexually dangerous, and testimony that was made by that expert witness during the course of cross-examination established that the burden of proof was not satisfied. To begin with the evidentiary issues, Mr. Mackey has been convicted of one criminal proceeding that involved sexual offenses. That was the proceeding from 2008.
Counsel, we are familiar with the facts. Can we hone in, for the sake of simplicity, on the police reports with regard to the incidents involving the boy we will refer to as Cole? In terms of the plea bargain, with regard to those offenses, you say in your brief that he pled to assault and battery as a lesser included of the indecent assault and battery on a person under 14. That's correct?
That's what the docket reflects, yes, Your Honor.
Okay, but isn't it true that assault and battery is actually not a lesser included offense of indecent assault and battery on a person under 14 because it does not require consent? I mean, the proof does not require consent. So it's not lesser included, is it? What are we to make of this?
Your Honor, I think that the answer to your question is I drafted the brief based upon what the underlying docket from that proceeding had shown in Middlesex. I would agree with the court's assessment that it really doesn't satisfy the lesser included, but I think that goes to the larger issue of we don't know exactly what those two guilty pleas he tendered to the two assaults and batteries pertain to. I mean, there were indictments against Cole or involving Cole involving alleged rape, indictments involving alleged indecent assault and battery. Actually, there were a total of 10 indictments that were brought. All we have is just two bare convictions for assault and battery, which we don't know what they were.
Okay. Counsel, I take it the transcript of the plea colloquy from that, those indictments are not before us.
They are not, Your Honor, no.
What are we supposed to make of the fact that the sentences on the simple A and B include such conditions as staying away from children under the age of 16? Not something you typically find in a normal A and B.
Well, Your Honor, my response to that would be Mr. Mackey's position is that the two assaults and battery, the underlying factual predicate was that he was disciplining Cole using restraint techniques that he had learned from another foster child who had been at Perkins School. That's what Mr. Mackey testified to at trial and doctors during the course of their evaluations. So my response would be that while you're right, that type of probation condition typically doesn't apply in an assault and battery type conviction, that could have been as much the reason for that particular proceeding as anything else. Cole was a foster child of Mr. Mackey's. I can assume that perhaps the trial judge had decided that he didn't want Mr. Mackey taking on any more foster children, given the fact that he had pled guilty to two assaults and batteries, which could have been dealing with some kind of a wrongful disciplinary process. And I think that, again, Your Honor, given the Commonwealth's burden of proof, given the circumstances at play, I think that that's as reasonable a determination as anything else under the circumstances, because we don't see, aside from that, really indicia that this was considered a sex offense. Mr. Mackey testified at trial that, in fact, the Commonwealth only decided not to proceed with the sexual offenses once the Commonwealth was satisfied that there was no sexual contact involving he and Cole. Now, admittedly, that's Mr. Mackey's trial testimony. He has his own perspective on this matter, but we don't have anything on the other side or anything on the trial record that would indicate that what he's testifying to was not accurate. And
So,
under those
counsel,
yes,
the Commonwealth argues, though, about this particular plea that it still qualifies as a sex offense under the statute because the definition includes any offense, the facts of which under the totality of the circumstances manifest a sexual motivation or pattern of conduct. And they say that the police reports are explicitly admissible and would satisfy that standard. What do you say to that?
I would respectfully say the Commonwealth is mistaken in this context because, again, Marquardt makes it clear that police reports develop some indicia of reliability when they're resulting convictions. What we have here are allegations from Cole, predominantly almost exclusively from Cole, because there were no other eyewitnesses. There were allegations raised by Cole. The Commonwealth saw fit during the course of its pre-sentence or pre-plea investigation to accept 2 guilty pleas for assault and battery only. So I would respectfully suggest that under these circumstances, the reports are not, there is no sufficient indicia of sexual misconduct that would make these police reports admissible. And in fact, these police reports fall squarely within the Marquardt reasoning, which is that without a conviction, not admissible.
Now, counsel, there is at least one difference with Marquardt, and that is, in Marquardt, the relevant charges were no prost. Here, they were filed. Does that make a difference?
I would suggest no, it does not, Your Honor. And the reason I would make that argument is because there was still no finding of guilt. There was no determination that these allegations raised in these reports were actually happened through a finding of guilt, or even if it had been possible at the time, if there had been a continuance without a finding or something, there could have been perhaps some indicia of guilt, but we don't have any of that here. We just have a simple plea to 2 assaults and batteries with no real underlying understanding of what the factual predicates for those pleas were. We have Mr. Mackey's testimony that they involved discipline, non-sexual, but we don't have any of the Marquardt requirements for a finding of guilt that would make these reports admissible.
Now, in terms of the probation records themselves, aren't those just allowed in by the statute?
Your Honor, I put that in my brief. I made the objection to that in the brief. I recognize, of course, that Mazzarino doesn't agree with me. The reason I brought that out, and I would respectfully largely rely upon for that particular piece of the argument, my brief, is that my position is that the statute is a bit ambiguous. It does say probation records, but I think that the more reasonable interpretation of that, and this is of course not consistent with what the court has held in Mazzarino, my understanding or my interpretation of that is if a person, for instance, is convicted of indecent assault and battery and placed on probation for a number of years, then his interactions with the probation officer during the course of that probation period, sexual offender treatment records, any violations he does, that sort of thing is what the legislature more reasonably determined to be admissible when it said that all probation records, just a sheet of paper that shows what offenses were charged. I know that falls under our administrative situation under the probation department, but anybody could do that. And what I mean by that is administratively, that could be done by the clerk's office or any number of places. And I still think that what the problem is, it raises when a court or when a jury sees a host of convictions and they don't understand necessarily what it means when it was dismissed or no prost or found not guilty. They just see 2 counts of rape, 2 counts of indecent assault and battery. And I think that inherently creates an unfair situation because there is no context. It's just these allegations of sexual misconduct that are inflammatory and are shown. And in a case like this, I think that problem is exacerbated because now we have, in addition to the Corey reports that show all of these highly inflammatory sexual accusations, we have the police reports, and we even have the judge's description to the jury at the very beginning of the case.
Yeah, what are we supposed to deal with that? Do you have cases that deal with the summary of the case pre-trial to the jury venire?
Nothing that I could find, Your Honor, aside from what I put in the brief, but I think the standard still applies. The Marquardt type standard would have to apply to that because, again, what we're doing at this point is presenting the jury of evidence of non-convicted accusations. And I would argue that, in a sense, it's even more prejudicial than a police report because a police report, a jury member can read the police report and believe it, but that's a bit different than sitting in a courtroom and having a judge in a robe telling the jury that these things happen. And in this particular case, that's where we were with the jury veneer. The defense attorney objected to that prior to any of these at the very beginning of the case before the jury panel was even introduced into the room. But what happened was, as laid out in my brief, the the trial judge first discussed, well, not first, but discussed the Cole allegations in graphic detail. So it had occurred over the course of 5 years. It involved coerced watching of masturbation. It involved dissemination of pornography, oral rape, indecent assault and battery on about two times a week, oral rape once a month. None of this came out as in the form of any sort of convictions. And also during the, I'll defer to the court if you want me to stay solely on Cole, but there was also an accusation or a statement by the trial judge during the jury description that with regard to the governing offense involving Allen, the trial judge told the jury that in April of 2008, the Clinton Police Department learned that Mr. Mackey, quote, may be sexually abusing several juvenile males.
But counsel, don't those all come in under Givens and McCool? I understand an argument could be made pre those cases that based on Marquardt, that stuff came out, but Givens and McCool, albeit divided decisions, seem to close that door to you.
I would respectfully disagree, Your Honor, because I think the linchpin here is Givens what happened in our case is the governing offense involving Allen were 2 counts of oral rape that occurred on 2 occasions in a car, where the only people in the car were Mr. Mackey and Allen. Brett was nowhere to be found. Givens is, I think, markedly and distinguishably different in that Givens involved contemporaneous assaults where both children were in the backseat of the car at the same time. And in fact, Givens talks about the temporal proximity and the contemporaneous nature of it, where one child was assaulted against in the backseat, the other child was not. The child who was not assaulted against, the police report still came in because it all happened at the same time and in the same place. This is a fundamentally different set of circumstances because Brett was nowhere near the two offenses which Mr. Mackey was convicted of doing. He wasn't in the car. They were the testimony and the records report that Mr. Mackey and Allen were actually
so you're saying the reports can come in, but the judge should have redacted the stuff involving the child we will call Brett.
Yes, Your Honor. Yes, obviously any reports involving Allen could have come in, but the problem here was that those reports also included the reference to Red. In fact, it was trial exhibit 9, I believe, which was the Clinton police report, actually has a handwritten statement by Brett's mother that said that, Brett pointed to his private areas and said that George touched me here. Again, Brett wasn't in the car at the time of the 2 governing offenses, and there's no conviction. In fact, Your Honor, respectfully, there wasn't even any charges. I mean, Mr. Mackey was never even charged of any misconduct involving Brett, and yet this jury saw police reports that said that he had touched Brett's penis, that he had given pornography to Brett, and there was just no allegations whatsoever to that effect. So for those reasons, Your Honor, I would respectfully suggest that the jury should not have heard about either Brett or, for the reasons I've expressed, Cole.
Counsel, one more question from me, and then I'll check with my colleagues. But on the sufficiency issue, for purposes of sufficiency analysis, don't we take into account the police reports involving Cole, regardless of whether or not they were improperly admitted?
I would say no, Your Honor, because again, we don't have, again, if we go back to the Marquardt.
But on sufficiency, under Farnsworth, under Cepheus, it seems pretty well settled that for purposes of sufficiency, you look at all the evidence that was admitted, regardless of whether it was properly admitted.
Your Honor, you're correct with the standard that's cited. Again, the allegations involving Cole, though, involved when he was from 12 to 17 years of age. We have no indication in those police reports whether or not Cole was prepubescent or not. Dr. Joss had testified, as had, I believe, the other doctors, that pubescence is one of those things that happens at or around the age of 13, but there is no hard and fast cutoff, 1 year earlier or 1 year later. So we don't know.
I think I understand the argument. Do either of my colleagues have any questions? Hearing none, we will now hear.
Chuck?
Your Honor, I think Justice Henry was saying something, but she was muted.
Sorry, I was muting myself because we have some noise in the background. With the respect to the convictions related to Cole, can the jury be told about the condition of probation and that he violated it?
I believe he can, Your Honor. Yes, they can be told that he had a condition that he violated, but I don't think they were entitled to know about all of the allegations of other misconduct that never led to a conviction.
Anything else, Judge Henry? No. Thank you very much. And now we will hear from the Commonwealth.
Thank you.
Good morning, Your Honor. May it please the court. Donna Marie Heron, Assistant District Attorney representing the Commonwealth. As to the first issues, Your Honor, regarding Cole, the Starkey's case out of this court is right on point. In that case, the defendant was charged with rape of a child, but pled guilty to assault and battery. And this court found the fact that the defendant, or the respondent, my apologies, the fact that the respondent was able to negotiate a very favorable plea deal, which clearly happened in the case regarding Cole, doesn't negate the underlying facts of the case.
But counsel, as you know, in Starkis, the respondent admitted that he had raped the 14-year-old. Why doesn't that make all the difference in the world? And by that, I mean, how can you harmonize Starkis and Marquardt without that key fact?
First of all, Your Honor, that wasn't the holding of Starkis. Starkis found that it was admitted and then said even if we were to conclude it wasn't admitted, it didn't prejudice the respondent in that case because at trial he admitted to raping the girl. So it wasn't part of the opinion that him raping the girl as was part of the opinion that it was admissible. Why this court addressed it was saying even if you were to conclude it shouldn't have come in, it didn't prejudice the defendant because he admitted that he'd raped the girl, and that is found on page 333 of the decision.
Yeah, but counsel, I'm looking at the part of Starkis in which they talk about whether there was error. And we said, and I quote, here, Starkis was able to negotiate a very favorable plea bargain, but that does not negate the underlying and undisputed fact that the incident involved the rape of a 14-year-old girl.
Yes.
In this case, how can you say that the sexual offenses against Cole were undisputed, where the only evidence I see on the record is the defendant testifying that they were not sexual and that he never admitted the sexual nature of the allegations when he pled to assault and battery?
Because the defendant was originally charged with indecent assault and battery. And then he pled guilty to assault and battery. For whatever reason, that was allowed. And the defendant received...
Wouldn't we have to know what the plea colloquy was to understand what he actually admitted to?
No, because you have the police reports, which were used to support the allegations. I mean, the fact that I think Starkis is clear, the fact that he was charged with a sexual assault and was able to plead guilty to a non-sexual assault comes in because he's able to get a fair and very favorable plea bargain. And we have the police reports, which underlines the complaint, which showed the actions for which he was indicted for and which he was arrested for.
Well, the fact that the police reports say that doesn't really answer the question as to what he agreed to, what was the factual predicate to his plea.
I would also add,
you'll understand.
I'm sorry, Your Honor.
Right, we understand that even though the Commonwealth may allege a set of facts, that the defendant before pleading guilty can say, well, my plea is to this subset of facts, not everything that you're alleging, right? And if that happened and none of that ended up encompassing the sexual conduct, then we have a different scenario.
I would respectfully disagree. I think Starkis is the fact that the underlying case that started this was of sexual nature, and I asked the court to also look at Torres from this court, in which that defendant was charged with rape and assault and battery with a dangerous weapon and was allowed only to plead guilty to assault and battery with a dangerous weapon and not the rape. And this court held that the underlying facts of the rape were admissible even in that case as well, because he got a very favorable, just because he was only allowed to plead guilty to assault and battery with a dangerous weapon did not negate that he originally was charged with rape.
But
And it was a
Counsel,
crime. So that's Commonwealth v. Torres out of this court, which is cited in the Commonwealth.
but counsel, in Torres, there's similar language in terms of the undisputed sexual nature of the allegation of the case. I mean, you make a very good point in your brief that sexual offense includes this catch-all category of what would other be non-sexual offenses that are wrapped up with sex. And the A and B here clearly could be sexual offenses, but doesn't the Commonwealth have to either prove that or have the defendant admit that before it can then take allegations in a police report and have them introduced as reports of prior sexual offenses?
I read my reading of the case, which and is that the Starkis and Torres, the underlying facts, which would be the police reports, which supported the Cole allegation, were sexual in nature. Other than the defendant's, I would suggest testimony, which was not. I mean, he denied the rape of Allen, for which he was convicted. So I would suggest you can't put much weight into Mr. Mackey's testimony, given that he's explicitly denied charges he was found guilty beyond a reasonable doubt on. But the fact that the underlying charges clearly were of sexual nature based on the police reports, and the fact that he was originally charged as an indecent assault and battery, allow it to come under Starkis and Torres, allow it to come into evidence, the police reports to come into evidence, which is different from Markovet, which was no process charges. So I would suggest, based on those things, that the judge, after did a full review of both cases, because when this was brought up, the judge 3 times went back and said she'd read the cases. And I would suggest Judge Sullivan's reading of the law is my understanding of the law, and that under both those cases, given what I just said, they were admissible.
What are we to make of the judge's pre-jury selection statement, which, speaking only for myself, I find rather extraordinary, where the judge detailed not only detailed the allegations against the respondent with regard to Cole, but stated it as a matter of fact. Didn't even say, the Commonwealth will introduce evidence showing X, Y, and Z. He said the respondent did X, Y, and Z. How is that possibly proper?
I honestly don't know how to answer the question, Your Honor. This is my first SDP brief, so I'm not thoroughly involved with the law. I just know that the police reports were admitted, so she could rely on the police reports, which are going to come into evidence.
We're talking pre-evidence, pre-jury selection. This was the judge's summary to the jury veneer,
which I do believe was edited and agreed upon by the parties eventually, but I'm sorry, Your Honor, I can't answer that question. I apologize.
But the summary was taken directly from what the Commonwealth had offered the judge, and the summary was stated, every sentence was stated as a matter of fact. This is the history of the case. This is the history of this gentleman. And not simply as these are the allegations that you'll hear, but to myself as well, it appeared that the judge was reciting to the jury in great detail. As a matter of fact, this is the history of what has happened in this case.
All the Commonwealth can say, and I apologize for not being able to fully answer your questions, is that those allegations, those police reports ended up going into evidence at trial. The undisputed convictions regarding Allen were not disputed by either party. Sorry, I can't add anything further onto that. I apologize.
Counsel, the respondent makes a confrontation clause argument here. In Marquardt, the respondent made a confrontation clause argument, and the court dealt with that in Marquardt and said, oh, so long as the Commonwealth complies with the rules we're laying down here, then we don't need to deal with the confrontation clause. It did not say the confrontation clause does not apply in this quasi-criminal context. Have there been any cases of which you are familiar with that since then the SJC has dealt with whether the confrontation clause applies in this context?
I am not aware of any decisions, Your Honor.
Oh,
I would,
no, continue.
that's okay.
With the 2008 conviction related to Allen,
Yes.
did any of the charged activity take place with the 11-year-old present?
None of the actual sexual assaults did not, but the whole, which I think under Givens is admissible, the whole grooming of the two, Allen, I'm trying to remember the names. Allen only meets Mr. Mackey through Brett, and that's how he meets Mr. Mackey. Because Mr. Mackey was friends with Brett to begin with, and he routinely takes both boys out, and as all experts testified to, was grooming both of them by giving them presents together, taking them out together. And it just so happens on the two occasions of the actual rape that I believe that Brett had been dropped off, and then took Allen to the boat ramp, and that's when the sexual assaults occurred. But I think under Allen, it shows a pattern, and it shows it's relevant to admissibility to related offenses. So I think it was admissible under Givens, given that.
So your point is the two sets of offenses were sufficiently related that the judge did not abuse her discretion in allowing this in?
Yes, Your Honor, that is the Commonwealth's position regarding the Clinton police reports, which were admitted without objection.
Well, why didn't the motion in limine preserve that? Anyway.
It's the Commonwealth's position that the motion in limine was a general one, which said all uncharged conduct. But at the hearing on his motion in limine, defense counsel solely focused on all the police reports regarding Cole.
I think, counsel, I think you may be correct that he emphasized more the issues related to Cole, but I think you need to take the word solely out of that.
Primarily, and then when at trial, when the Cole, anything related to Cole came up, defense counsel objected, but when it was related to the Clinton police reports, there was no objection to the omission of the reports. But even under the prejudicial standard, if this court would disagree with me and argue under the prejudicial standard, under the Givens case, I would suggest there was no error and therefore it was no prejudicial. And I would just say for the Board of Probation record that this court has explicitly in Torres and in Mazzarano has said under the statute, it is comes in unredacted. And that there's nothing in the Marquardt case, which was argued under Torres. They explicitly reject that argument that Marquardt says that the whole unredacted Board of Probation record could come in because, as they noted, Marquardt involved police reports and witness statements, while the Board of Probation record does not. And this court has found that explicitly under the statute, it's admissible.
Counsel, turning to the cross-examination of the experts, the defendant in his briefs says that it can't be that simply because it's cross-examination that the Commonwealth can get all of this stuff in, that the statements on which the Commonwealth is relying were in the context of direct and cross of the Commonwealth's experts. How do you respond to that?
My understanding of the argument, I was, to be fully blunt, I didn't quite, my understanding of the argument the defendant has raised is that the cross-examination of his expert, Bell, was erroneous. Yeah, Dr. Bell, because of, especially regarding the static 99R, the uncharged conduct, which to note that the prosecutor didn't even get into the underlying facts of it. He just asked him whether he considered uncharged conduct. But it was undoubtedly, it was Mr. Mackey's witness. And Marquardt case makes it quite clear that that information can come on cross-examination, and it doesn't explicitly limit it to Commonwealth versus the respondent or defendant. It says opposing party. So I think it's quite clear that Dr. Bell was not the Commonwealth's witness, as I believe the defendant is trying to suggest, but was clearly the defendant's witness in this case. And therefore, under Marquardt, the Commonwealth was allowed to cross-examine their witness.
But counsel, wasn't the context in Marquardt would be the respondent's cross-examination of the expert witness, and that we have to take that in context?
To quote Margaret on page 338, those details may be explicited during cross-examination, but the decision whether to do so is a strategic one left to, quote, the opposing party. It does not say the respondent, it doesn't limit it to just the respondent versus the Commonwealth.
Well, so his response is, if you were to read Marquardt that broadly, you're really putting a respondent in a Hobson's choice where they can either put in the expert testimony that favors them, but know that this is basically opening the door to terrible, terribly prejudicial testimony. What do you say to that?
I said the SJC has explicitly allowed it under their case law. And but for calling, well, first, again, I'd like to note in this case too, that there was no details regarding those uncharged allegations, nothing of police reports or anything. He simply asked the expert how he came to his opinion and how he came to his numerical value under the as static 99R, and then asked him if he had considered both charged and uncharged conduct. He didn't get into the details of the uncharged conduct. So it's just under that, and under the Marquardt makes it quite clear that you do open the door by doing that, and it laid out the procedure that it is admissible.
But it's that, if I understand your argument correctly, you're saying the prosecutor here could have gotten into the details.
He could have, but he did not in this case.
Okay, counsel, do you agree with me that simple A and B is not a lesser included offense of indecent A and B of a person under 14?
I think you are correct in that.
So
but I know there's a lot of case law out there that says that just the defendant got a very favorable disposition that he necessarily shouldn't have, but was able to. But to your point, even if I do believe you're correct in that.
Yes, on the sufficiency point, your colleague is arguing that there was just no evidence about whether or not the Allen was pre or post-pubescent. What's your response to that?
My response was that he testified, there was his opinion that he suffered from a mental abnormality, which in his opinion was pedophilia, and the fact that that doesn't follow the DSM definition of pedophilia is irrelevant. And I cite the Hubbard husband case, the Souza case, the Reese case, which makes it quite clear, and the sexually dangerous statute does not follow the DSM statute. And therefore,
so to be clear, you agree there was no testimony about whether this person, whether Allen was pre or post-pubescent, or evidence?
Allen is the
13-year-old.
Yeah, the 13-year-old, which qualified. Oh, there was a confusing, I'd agree with you, there was ambiguous testimony as to the length of time. I think it clearly was pre-pubescent, but the length of the assault occurring, I think, was the challengeable, whether it lasted 6 months, I think was the portion that they were
well, the assault doesn't have to last 6 months, it's just the attraction.
The sexual interest in the pre-pubescent child has to last for 6 months. And I think that was the issue that they were arguing below that he didn't qualify for, that we couldn't establish that that's given the nature of his relationship with Allen, that it lasted for 6 months. So therefore that the sexual interest in Allen lasted for 6 months. But that, as I argued in our brief and citing those cases, we do not have to follow the DSM under the sexual dangerous statute, and that it's up for the jury to decide which expert they find credible. And just because the defendant had 2 and we had 1 doesn't mean it's insufficient.
Now, counsel, there is a dissent in Souza that argued that surely the Commonwealth is not bound by the DSM, except perhaps when the Commonwealth's expert expressly relies on the DSM as the basis of his opinion. Do you read the majority in Souza as expressly rejecting that theory?
I do.
And
I think
it's fine to say yes.
Sorry, yes, I do, Your Honor. And I would also note, even though if this court were to say the evidence versus Cole was not admissible, we did from the police reports learn that starting at age 12, the sexual interest in Cole began and lasted over 6 months. So I would suggest that would satisfy that criteria.
Okay, do either of my colleagues have any further questions? Seeing none, thank you both very much. Excellent argument.
The case is now being recorded.
Thank you very much. We are back on the record with our third case of the morning, which is 2020 P490, Commonwealth versus Hermano Joseph. We are back with our original panel from the morning. And I just want to remind the parties that we have read the brief, so we are familiar with both the facts and the arguments. So I would urge both arguing counsel to cut to the chase to the extent possible. And with that, I will turn the floor over to Attorney Patton.
May it please the court, Your Honor, the central issue that has to be decided in this case is whether or not the instructions which the trial court judge gave to the jury, basically informing them that they could consider other acts of other people with which the defendant was not charged as constituting a common scheme. And as to whether or not that caused the jury to have injected into their considerations impermissible propensity evidence, which in turn undermined the defense proffered by the appellant of based upon the question of the credibility of the resident number 5, who was the alleged victim of the appellant. Specifically, this case, it was made clear on the record, in fact, was not a joint venture case. There was no joint venture that was alleged and instructed among all of the various staff members of Casa Isle. Also, obviously not, there was no accessory charges alleged, there was no conspiracy. What was done was that the Commonwealth was allowed to proceed on the argument that a quote unquote culture existed at this facility. The effect of that was to create an inference, an impermissible inference, I believe, that if somebody was a staff member at that facility, then that person had a propensity to engage in what is described by various witnesses as something called an orange chicken assault on residents of the facility.
Why would it necessarily be, why would the inference be that any staff member had a propensity to engage in it rather than the inference that staff members had knowledge about it because it was part of the culture?
Well, even there, it's the concept of saying there was a culture there to begin with. What you have is you have some individual named defendants, not the appellant here, but you have the defendants Andre, LaRoche, and DePina mentioned repeatedly as being involved in these events. You have unnamed staff. You have a great deal of that in the course of the transcript of saying, well, staff said this, staff said that, staff did this, without any identification whatsoever. The overall facility, however, did not have this sort of behavior as part of its role. I mean, it was meant there to provide facilities for DYS committed people, right? And so you have evidence of individuals doing this this type of behavior, but to make the jump from that to say, well, it was a cultural thing, is actually based on the evidence here speculation. For instance, of the Commonwealth's witnesses, one of them, Christopher Hester, was a staff member who testified that he was at the facility. It was 7 or 8 months after he began working there that he first even heard of the name Orange Chicken. Doesn't remember who told it to him. And he testifies that he asked around what it was, but he had never heard of it. And of course, the Ms. Conti, who was the director of the facility, again, a Commonwealth witness, testified how she had reviewed all the tapes, all the security tapes and whatnot, and that found no evidence of this. So that what you have is you have specific accusations against individuals. And you don't even have, the Commonwealth did not even present evidence as to what the total number of staff was at the facility. So you have, the only evidence on that was the testimony by resident number 1, who said he remembered it as being about 18 to 20 people. So what you have here is actually the Commonwealth's evidence of identifying a limited number of people that were engaging in or alleged to have engaged in these particular acts. The only evidence of the appellant having engaged in any such act was the testimony of resident number 5. And that goes right to the question of that person's credibility. So that when the instruction is given that, well, the jurors can consider whether or not there's some sort of common scheme.
Counsel, if memory serves me correctly, your client was acquitted of a number of the charges, correct?
That is correct, Your Honor.
And so how are we supposed to deal with that? If your client was so prejudiced by being tied to a culture of these violations, it would seem that the jury were able to sort through that and to find him guilty only where they thought the evidence supported it.
Well, the response to that, Your Honor, is in fact that those verdicts would tend to support that the convictions did take into account this propensity evidence. Why? Because he was convicted of an assault and battery in a fight on the basketball court. Had nothing to do with any evidence of an orange chicken. He was convicted of orange chicken events. The ones he was found not guilty of, there was a charge that he had assaulted resident number 2 in an orange chicken situation. However, when resident number 2 took the witness stand, he did not testify to ever having been assaulted by the appellant. And that resulted in a entry of required finding of not guilty. As far as the charge of assault and sexual assault and battery of trying to push his genitals against the buttocks of the resident number 5, he was found not guilty of that. But that again was outside the parameters of this so-called orange chicken that was being attributed to all staff at the facility. The convictions he got were specifically related to, or alleged to be within the context of that so-called orange chicken. So in other words, the argument could be made that that actually shows that the jurors were focused on that where you didn't have the evidence of that, they tended to find him not guilty. Where they had the evidence of the so-called culture, they found him guilty. So that there is a suggestion here, I think a strong suggestion, that those jurors, when they were looking at this, took that into account. And in fact, the Commonwealth in its brief here has said that they would not have gotten a conviction without this evidence of the so-called culture related to the orange chicken. And so I think that it's quite clear that there is this, again, this inference of propensity on the part of any staff member that by virtue of being a staff member, by the virtue of being a staff member, the appellant had a propensity to engage in orange chicken. And so that when that was presented to them, even though they might have not found the resident 5 credible on these other charges, that could be the thing that put them over the top at that point to convict him on that. And that is suggested by the Commonwealth's own evidence. I mean, their own statement in their own brief that without this, they.
Counsel, I'm not sure Mr. Lynn will go that far, but we can ask him.
Well, I'll just say that I have cited the particular reference in my reply brief, and I believe it's at page 16 or thereabouts of their brief, that they say that they needed to have this because the resident number 5 would not have been believable without it. And so I think in the end, the entire case of the Commonwealth focuses on this concept that by virtue of being a staff member, there is an inference to be drawn that somebody would have been involved in this. And I think it's an impermissible inference on the evidence and on the law, because again, it's not a situation where it can be shown that all people in this operation engaged in these types of activities. That's where Commonwealth versus Wadsworth comes in. In other words, a person simply by being a member of a gang, even though other gang members commit certain crimes, does not create the inference that that person will commit those same sorts of crimes. On the other hand, and I use the comparison where if you have evidence, say with a gang where the, as it is, initiation gang member or somebody becoming a gang member swears fealty to, okay, we're in gang A, we see anybody from gang B, we attack them. That's different. But to just say that because somebody is present as a gang member, or in this case, as a staff member, because there are people who engage in this activity, that an inference can be drawn that that person has a propensity to do the same sort of thing. And I think that that is exactly what you have going on here, particularly when one looks at, I've mentioned the multiple hearsay that's put out about staff said this, staff said that. That collective use of that term staff throughout the testimony of the witnesses here, that it's very, very hard to say exactly who was doing what, and if at all, and who was providing what information to whom. So that you're left in I believe, in a very speculatory situation if you were a juror. The one thing the juror would hear is this idea of common scheme, which for a lay person, again, unlike a joint venture, where there are certain instructions that have to be given to a jury about what it is, there are legally recognized elements, if you were, that will show that. When talking about this common scheme and the concept of a culture There is none of that. The jurors are left on their own in that regard, and that's where Commonwealth Andre really comes in. The SJC decision from 2020, which I've cited in my brief, that the importance of, if there is going to be an instruction to a jury regarding or allowing them to receive evidence that might be propensity, it has to be very, very specific. It has to be explained to them, if you will, in a case like this, what exactly is the court talking about when it tells them they can consider a common scheme or pattern of evidence. Because as the SJC is said before, Creighton, pattern evidence is propensity evidence. And that's what exists in this case here.
Yeah, Counsel, I'm afraid your time has expired. Let me see if either of my colleagues has any questions. Seeing none, thank you very much. We will hear from ADA Lynn.
Good morning, Your Honors. May it please the court, Paul Lynn for the Commonwealth. The evidence of the culture at the facility here was essentially the opposite of propensity evidence. Instead of being evidence that these people were predisposed to commit these crimes, it was entered as evidence to explain conduct that an individual would be unlikely to engage in absent this culture. As the defendant himself put it, and I apologize for the profanity, that's how we do shit here. That's the evidence for what this, that's the purpose for which this evidence was admitted. And even in the cases that my brother cites, the courts say pattern evidence is propensity evidence unless it's meaningfully distinctive. And here you have very distinctive conduct. You have this essential ritual where they bring someone into the cafeteria, they pull down his pants, and they whack him on his bare buttocks with this orange sandal. This is conduct that would seem very, very, conduct that would be unlikely to be committed by an individual outside of the setting. It's not been too long since this was an accepted part of group fraternal culture. So that's the purpose, not to show that these were bad people, but to show that this had become accepted conduct among members of the staff. And we didn't have to or try to prove that it was all the staff. We simply offered evidence that it was an accepted practice among these six, at least these six charged supervisors or guards.
So, Counsel, what cases, and by that I mean court precedent, do you have for culture evidence like this? You mentioned fraternities. Surely in some of the recent fraternity hazing cases, there must be some instances where this issue has come up, or?
Not that I know of. Thankfully, just I don't know of any case that still involves ritual paddling or anything like that. But I certainly cite Sharp and Pillai, in those cases in which you have this pattern of conduct, in which you have something that's very distinctive. In Sharp, it was the defendant's tendency to become violent during disputes with his girlfriend about money. In Pillai, it's this common scheme the defendant uses to sexually assault people who sleep over with his daughter during who come over for sleepovers with his daughter. And he does this. That's how he does this. That's his pattern of conduct. That's how he accomplishes what he does.
But isn't, as you relate to those facts, isn't the context markedly different? We're talking about one defendant and his alleged pattern of practice. Mm-hmm. Here, we're talking about a culture among several individuals, and then you have a defendant charged, and the Commonwealth's evidence includes this culture evidence around him.
That's true. That I can't deny that that is a difference, but it still falls within this category of cases where you have an act that seems odd in and of itself, but when you put it into context, it makes more sense. And that's not propensity evidence. The other thing that makes this...
Wasn't a lot of the evidence simply the testimony relating to other events that were against the other defendants?
Oh, yes, absolutely. Yes. But the vast majority of the evidence that it was admitted was evidence of acts that were actually charged against the other defendants. So those had to come in the joint trial. Obviously, my brother claimed in his brief that the cases should have been severed sua sponte. But yes.
Well, the judge seemed to be very astute at giving curative instructions once any of that testimony came in as well.
Very astute. He made it very clear that there was no joint venture here. You could only convict the defendants, that is, the jury could only convict the defendants based on their own conduct, based on things that they actually did, that no one was charged as a joint venture, no one was charged as a conspirator. They could only consider statements that were made against the declarant of that statement. And of course, again, throughout the trial and in the final jury instructions, they could only convict the defendant based on his own conduct. Another thing that makes the judge, I mean, first of all, as you say, the judge exercised his discretion extremely responsibly. He excluded quite a bit of evidence of further events, and he made it very clear that the only non-charged conduct he was going to bring in was conduct that was inextricably intertwined with charged conduct. And then, even then, he made it very clear, for example, the assault on AS that resident number 5 testified about, which he said took place at the same time as an assault on resident number 5. The judge says, I'm only admitting this evidence because it took place at the same time. The defendants are not charged with any assault against AS. You cannot consider this as evidence that the charged conduct occurred. It's being brought in only because it happened at the same time. And the same thing, the other category of non-charged conduct that he brought in was conduct that was used to intimidate the witnesses, and the witnesses had to explicitly testify that this was an act that intimidated them before the judge would allow that in. So the judge was rigorous. The judge did exactly what we expect and hope judges to do, which was to exercise his discretion very responsibly in this case. The other reason the judge acted within his discretion is that all of this evidence comes from the same sources. The only evidence against all of these defendants, including the defendant here, is the testimony of these residents. And the unified defense of all of the defendants at this trial was, you can't believe these guys. You would not trust them. We have them. We have caught them in lies. They have a motive to lie. Don't believe them. And the evidence of the culture, the evidence of the uncharged misconduct, the evidence of the conduct committed against other defendants, all comes from the same source. These residents that the defendants say you shouldn't believe. So there's not like a difference in kind here. This isn't like Wadsworth, where a police officer gets on the stand and says, oh yeah, this guy's a gang member. All of this evidence comes from the witnesses.
I thought there was one witness who was a former employee.
That is true, but he again is talking about his firsthand experience. And he actually, as my brother points out, is a rather weak witness for us, because he says, he didn't even hear the term orange chicken until several months into his employment, and he doesn't give a lot of details about the orange chicken. He just says, "Yeah, I heard of the orange chicken." So this isn't evidence that was more prejudicial than probative. We know that the jury didn't find guilt by propensity because they acquitted not only this defendant but all of the defendants. My brother picks apart the verdicts in his case, but if you look at the verdicts as a whole, there were lots of the orange chickens that the jury found that the defendant's not guilty of.
Okay. Counsel, as I expect you're aware, this is the third appeal of one of these cases that has reached the oral argument stage.
Yes, Your Honor.
To the extent you know, were all of the issues raised here also raised in the earlier appeals?
No, they're separate issues. The first two cases, which were DePina and LaRoche, involved the same issues in those two cases, but they're different issues than are raised here. But everyone has raised the issue of this extrajudicial, or not extrajudicial, I should say, this. But yes, this uncharged conduct. That's universal to all three briefs. Also, as I've pointed out before, the judge always instructed the jury, rigorously, repeatedly, clearly instructed the jury that they could only convict the defendant based on his own conduct. He also repeatedly instructed the jury, although my brother calls it contradictory, that they could not consider this uncharged conduct as propensity evidence. They couldn't use it as evidence that these defendants were bad people. They could only use it to show this pattern of conduct. And as I said, this is a very distinctive pattern of conduct. This is a situation in which you have a cultural allowance of something that an individual might not do. These are admissible. These are purposes for which this evidence was properly admissible. If there are, I will take any other questions the court may have.
Seeing none, I think we have your argument. You have 4.5 minutes left if you want to keep going or rest on your brief.
No, I will otherwise rest on my brief, Your Honor. Thank you.
Thank you both very much. The case is now submitted.
Case is now being recorded.
Thank you very much. We are back on the record for the fourth case of the morning. It is 2020 P558. It is a SORB matter. John Doe number 523899 versus SORB. I would remind the parties that the case is impounded. So please, no names of the parties. Obviously, you can refer to the experts by name. And I would also remind the parties that we have read the brief, so we are familiar with both the facts and the main arguments. So therefore, I would urge both sides to cut to the chase to the extent possible. And with that, I will turn the floor over to Mr. Campbell.
Good morning, Your Honors. Attorney Brandon Campbell for John Doe. If I am reading my brother's brief correctly, the SORB is conceding that what happened in this case constituted an error under Doe 23656, but I understand SORB to be arguing that standing behind waiver and a lack of prejudice. So the Doe 23656 case came out from the SJC while this matter was pending in the Superior Court. So neither of the parties had an opportunity at the hearing level to at least apply that precedent to the case, because obviously it hadn't been issued yet. And what Doe 23656 stands for is it's an extension of Commonwealth v. Hunt, which said in the SDP context that it's unfair to use a refusal to participate in sex offender therapy conditioned on a waiver of confidentiality in an SDP case. Same thing applies now in the SORB context. And the reason is it puts defendants and petitioners in an untenable position. It is a Hobson's choice whether or not to participate in treatment and say things that could cause legal complications, or not say anything and then have that used against them. And admittedly, there is research that says that sex offenders who drop out of treatment do statistically present a higher risk of reoffense. But be that as it may, the SJC has said that even though that may be true statistically, it is unfair to put that onus on petitioners in SORB cases and even SDP cases.
Okay, counsel,
Does the, I'm sorry, go ahead.
No, I'm after you.
Does the petitioner, the inmate, have to be specific as to the grounds when they refuse treatment? In other words, here it was, I'm not guilty, or am I? He said, my lawyer said something like, I'm innocent, so I don't have to do this. It had nothing to do with the signing of a waiver that whatever he said could be used against him. Does he have to raise that in order for the new case to apply, or is it presumed? Or
no, and my brother does make that argument. And by the way, he said that I'm going to get my case overturned on appeal and I'm innocent. All of this is based on the psychotherapist patient privilege. And there's no,
I understand that concept, but it sounds like he was saying, I don't need this, as compared to this could affect me.
I don't see a distinction in any of the cases that would make that narrow distinction. It's really about, is he going to be penalized if he, so he goes on the advice of counsel, he says clearly. And by the way, this is a person who's speaking English as a second language. If you look at the dates of his, he didn't get a decision on his appeal for about 2.5 years. So inferably in that time, it was very early in the appellate process. There probably wasn't even a transcript at that point. He has an attorney who's telling him, you don't want to talk about your case. And any attorney worth their salt would have said the exact same thing. I don't think that there is any way to distinguish, he's not going to have to say, oh, I am going to make an appeal based on duplicitous convictions, and therefore I don't need to talk about this in treatment, you can't use it against me. I don't see that all manner of topics are covered by the psychotherapist.
Right, but what you're suggesting is it doesn't have to be a specific objection to the treatment, just a refusal, period. Any refusal would equate to the application of the 23656.
Yes, that's what I'm saying. I don't know how you do it any other way.
In this case, there was an articulation of advice of counsel pending appeal.
As contained in the record submitted by the board, that's what the petitioner said. In more than one place in the record, it's memorialized.
Counsel, in any event, would you agree that your client did not raise the issue before SORB, or for that matter, before the Superior Court?
Obviously, it couldn't have been raised before SORB because, well, if he had a counsel that had the forethought, unfortunately didn't. But every case where the SJC has announced a new rule applicable to SORB cases, it's always been applied retroactively to all cases that are pending on appeal, and that's applicable whether or not it's constitutionally based rule change or non-constitutionally based. All of the
even where the issue was not raised, you're saying?
Even where the issue was not raised, 89230 that changed the standard of review on SORB cases applied to all cases that were pending. We say, oh well, that was constitutionally based. Well, I meant to say 380316. 89230, which was another one that had to do with the ability to move for export funds, was not constitutionally based. That was applied to all cases that were pending on a direct review at the time. So I think that this court has to consider it. The only way to distinguish it is to say that, okay, and I don't see any case support for this, is to say, well, he should have raised it in superior. The earliest he could have done it would have been after the complaint and after the dispositive motions were filed. But at that point, you've got to look at the reason for imposing waiver. We're really this court is really reviewing what happened at the hearing stage. It's not reviewing what the superior court thought of the hearing examiner's decision. And this goes to the interests and finality that are served by the waiver rule. They just don't apply in this context. And it's always—
Counsel, I don't think Mr. Chennai is arguing that this was waived in the traditional civil sense. He's saying it's instead subject to a review for a substantial risk of a miscarriage of justice.
I did not read his argument that way.
Perhaps I'm misreading. We will hear from him on that point.
I do think at a minimum it should be reviewed for substantial risk, but I don't even think, I found a case, the Gordon case. It's a very different context. It has to deal with, prices on alcoholic beverages and the Alcoholic Beverage Control Commission. But it was a somewhat procedural similarity in that there was a case that went before the board. There was an intervening appellate case that came up while it was on review in Superior Court. And then it went up to the next highest court, I think it was the SJC at that point, and said that, we're still going to review it in this context. So, and again, what I was starting to say is that, the interest and finality are always weak in these sort of cases. There's a dissent by Justice Gantz that I cited in my reply brief in a footnote where he talks about these cases are reviewed at least if the petitioner wants to every 3 years, and more so if the board finds some reason in between that 3-year deadline and the decision to come in and ask for a change in the classification. So and also there's just no unfairness to the board, because the unfairness comes when there's something they wanted to put in at the hearing level that they couldn't, right? But because they didn't neither side had that opportunity, frankly. So there's no prejudice to the board. This should be applied. This shouldn't be allowed to stand against this petitioner, going forward. Because if this court doesn't send it back, the board has the right to say, when my client comes up for reclassification in several years, they don't have to revisit this issue. They'll just look at what happened from the classification going forward, and this, this factor will, still count against them. And let me talk to prejudice a little bit, because, I think that this is a very prejudicial issue, in that this is really the only factor in this case that presents anything outside of the index case itself that would indicate any heightened risk. Everything else that the board relies on has to do with the conduct that happened during the index case. So if you look at all of the facts in this situation, this is a single, isolated, relatively brief instance of misconduct. This petitioner does not have any serious criminal history at all. He did great with rehab in prison, no D reports. He is 55. He's in an age with a reduced risk. He is looking at 10 years of probation with GPS. But for this error, this very easily could have resulted in a level 1. And I say that knowing full well, without taking away anything from the seriousness of the underlying index case, which it was very serious. And yes, there was a high risk factor that applies, but that has to be taken in the context of all of the facts. And the board is always quick to argue that this court should be slow to reverse because of the discretion of the hearing examiner and the expertise of the board. I would caution this court of, imposing its own judgment respectfully in place of the hearing examiner when there's this kind of issue that I argue could have made a difference between a level 1 and a level 2.
Do either of my colleagues have any further questions? No. Counsel, it sounded like you were summing up. I don't mean to put words in your mouth.
I'll rest on my brief. Thank you, Your Honors.
Thank you very much. We'll hear from Mr. Chennai.
Thank you, Your Honor. If it pleases the court, David Chennai for the board. It's actually kind of nice to be in here arguing a case that doesn't involve factor 2 for once. But the board's position is, again, on the factor 24, it's really 3 levels, which is 1, starting with that it was waived. And I disagree with my brother counsel's analysis on pending cases when a decision is made. On pending cases, I think you look at Commonwealth versus Figueroa, which is at 413 Mass 193, and Commonwealth versus LeBrand, which is at 405 Mass 634. Both of them stated that when a case is pending and a new rule comes out, that to apply to a pending case, the issue had to have been preserved from below. And in this case, it wasn't. And I think the citation my brother uses on Doe 151564, that issue of the expert witness was part of that case from the very beginning, even in the Superior Court. So the first position the board has is that this issue was waived. The second is that it's a circumstance where this individual claimed that he wasn't going to do treatment because of his attorney's advice, and that upon the appeal would be reversed because on innocence, but he pled guilty to the charges. So I think that undermines that understanding of what he was going to have happen, that he was actually innocent of the charges. And again, the appeal never argued innocence of the charges.
Counsel, before you get to number 3, what do you mean by waiver in this context? Because in the context of ordinary criminal cases, the language that the courts use are the issue was waived, therefore our review is limited to substantial risk and miscarriage of justice. Are you saying that the issue was waived in the traditional civil sense, or in the criminal sense that it's still subject to substantial risk review?
I'm arguing that it is waived, even on the civil side of this, and that the issue becomes whether or not there was a substantial miscarriage of justice. And that's why my brief goes into harmless error. And again, the harmless error being that if you took out the hearing examiner's factor 24, which has been done with other cases, in 23656, they took out the factor to allow the court to decide with the remaining factors, would it still result in the same result, in this case, a level 2 classification. The board's position is that if you took out factor 24, this individual's actions in 2014 against this girl were so grave, and the fact that he had been incarcerated pretty much since that time, and was incarcerated at the time of the classification hearing, that his future probation, which he got full credit for, his some credit for being 55 years old, and the moderate weight given to the other two, which is the stability, future stability in the community and his current living environment. By taking out factor 24, those 4 factors were not going to, at that point, based on what he did with the child, reduce him to a low level. And again, part of the reasoning being that he'd been incarcerated and was incarcerated at the time of the classification hearing from the time he pretty much committed the offense. And the offense itself shows some premeditation on this individual's part. He invites this girl to his niece to a soccer game, has other people in the car, goes to the soccer game, and then on the way home goes right past her town, drops them off, his friends off, and then brings her to another area where he sexually abused her. I think the factors that rise from that and those actions in 2014, again, this didn't happen in 1985, but in 2014, and he had been incarcerated since that time, is indicative of a high risk. And I do not believe that factor 24, if you took that out of the equation, would automatically, based on what the facts of this case were, drop this down to a low level. So in the end, even if you take factor 24 out, the board's position is he's still a level 2 sex offender. And this court under 23656 has the ability to make that determination at this level. So basically,
some questions about the hearing examiner's treatment of some of the positive factors, for example, the supports. What was meant by because he had the same supports before as he's claiming now? Why does that make a difference?
It makes a difference because you have to say, okay, he had this support system in place prior to, for some time, because mainly if you read it, these are all old friends of his, old family, the family members. He still, with this support system in place, committed the sex offense. And the support letters aren't showing us that they're going to do something different in the future. If he's got the same support system and they still give him the same guidance and supervision that they did prior to that, there's nothing in the current status of that support system that shows that he's going to get any less of a risk by that support system existing today. And I think it's just
network, the whole support network is invalidated. I mean, the fact you could have a support system who may not understand at some point understand that you had a problem, but once they become aware of the problem, they're still your support system.
Well, you got to keep in mind, they weren't eradicated in the sense that the hearing examiner did give credit for that, gave moderate credit. And the moderate credit rises from the fact that they did not in their letters explain what current support and guidance for rehabilitation they were going to give upon his release. They still talked about what a great guy he was, and they didn't really talk about what they were going to do for him in the future, which again, the factor requires at least to get the highest level of the factor, at least some indication of what they're going to do. And in this case, what they're going to do differently to support him and guide him and prevent him from being in these situations in the future. Again, the letters just really reflected about what a good person he was, how much they care for him, but really didn't get into the nuts and bolts of what they were going to do to help him. So the hearing examiner actually gave moderate weight to that support system. And really, the moderate weight, even if that wasn't a support system prior to the event, that moderate weight would have been given in these circumstances, again, because the support system isn't giving any indication of what they're going to do individually to help him down the road, which is required under the regulation to get the highest level of the regulation. So the hearing examiner gave moderate, which was acceptable, or at least was what should have been given under the circumstances of the community-based support.
What about, there was a reference to being offered a job, yet the hearing examiner characterizes that as being speculative.
Well, again, the individual had been incarcerated. The hearing examiner gave moderate weight to that evidence, but wouldn't give it full weight because there's no guarantee that when he comes out, he's going to take the job. We know he was offered a job, and based on that, while he's still incarcerated, that's well and good, but we do not know what steps he's going to take when he's not incarcerated. Will he take that job? Will he do something different? Will he become homeless? We don't know.
So everybody who is facing this determination in an incarcerated state, all of their outlook is going to be considered speculative necessarily.
Necessarily, yes. And again, the courts have said in the past that we're basing it on current risk and danger. And just the fact that someone's incarcerated hampers their ability to show their future stability is not enough. It does not obviate the board's regulation on that matter. So the courts have upheld the board's consideration of future non-incarcerated status and try to weigh that, and also consider the fact that some of it is speculative as to what's going to happen when they're released. Because again, we're looking at current risk and danger, not risk and danger after they're released, because we don't know what that's going to be.
But necessarily when you're talking about the future, you may be talking about people speculating, right?
Correct.
Your determinations about the future.
Correct.
But then to completely discount, I mean, it seems a little circular.
Well,
We're talking about the future, we're talking about predictions, then to say all of that is speculative, so we're going to discount it all.
Well, no, the hearing examiner didn't discount it all. He gave moderate weight to it, which he didn't give it full weight because, again, he's not out, he's still incarcerated. He does not have that job in hand in the sense that he's actually working the job. The hearing examiner didn't disregard it completely. He did give moderate weight to the fact that he does have the possibility of having that in the future. So I can't say that the hearing examiner obviated it based on speculation because it was based on speculation. The hearing examiner did point out, I can't give it full weight because of the fact that there is some speculative nature to this. So I don't think the hearing examiner completely disregarded it. I think the hearing examiner weighed it out in a common sense approach and said, he does have the offer. I will give him credit for that. But I can't give him full credit because I'm not sure that, he's going to in the future follow along with that plan. So so again, the board's position at this point is that the issue of factor 24 was waived. If the court, and that we should look at this as a substantial miscarriage of justice, and in that vein, looking at the circumstances, I don't think it can be shown that taking factor 24 out of the equation would have reduced this individual's risk to a low level. I think it would still be a moderate level based on his sex offending behavior, based on the recency of it, and the fact that he's been incarcerated since the time of that event. Unless you have further questions, I'd be more than happy to rest on my brief.
Seeing none, I thank you both very much, and the case is now submitted.
Thank you.
Thank you, Your Honor.
Case is now being recorded.
Thank you very much. We are back on the record for the fifth case of the morning. The case is 2020 P1209. The case is partially impounded, actually maybe even fully impounded, but in any event, the key for today is not to use names. The case is currently on our docket as mother versus father. Whether it remains that way, we'll have to see. In any event, referring to the parties as mother and father would seem like a good idea. I want to remind the folks that we have read the briefs. We're familiar with both the facts and the arguments, so I would urge both counsel to cut to the chase to the extent possible. And with that, I will turn the floor over to Attorney Roman.
Thank you. Good morning, Your Honors. Jennifer Roman on behalf of the father. Troublesome facts are to be faced rather than ignored. Only then is the judge's conclusion entitled to the great respect traditionally given to discretionary decisions. That's from Michelin versus Deschler, 96 Mass Appeals Court 815 at 818 from 2020. The trial court abused its discretion when awarding joint legal custody in this case by failing to address 3 significant categories of uncontested, troublesome facts. The 3 categories are the findings of the GAL, as reported in her 38-page report, which can be found at Appendix Volume 1, 119 through 156. The parties' inability to reach mutual decisions concerning the child's school and medical providers. And third, the negative impact of the mother's paranoid and distorted perceptions of reality on the parties' ability to make joint legal custodial decisions on the child's behalf. The court appointed Nicole Robinson, a licensed social worker as GAL, to investigate and make recommendations concerning the care and custody of the child. The court acknowledged the existence of her report as it was admitted as an uncontested exhibit, but made no findings based upon the guardian ad litem's report. This is particularly troublesome because of the findings that the GAL had found based upon her detailed and extensive investigation in this matter.
Counsel, not to put words in your mouth, but as I understand it, you're acknowledging that the judge obviously is not bound by the GAL report, but you're saying that the judge had to consider it and make findings with respect to it.
That is correct, Your Honor. And by not making findings regarding the GAL report, the court did not base its ultimate decision of joint legal custody after taking a review of the entirety of all the facts and how those facts may interplay with the child's best interests. Because if the court had looked at the GAL report in detail and made findings about that, there were facts that simply could not be ignored or set aside by the trial court. But specifically, the GAL specifically noted that ideally communication between the parties would lend itself to a joint decision-making ability, but that at the present, the parties did not have that ability. And the GAL further attributed that inability to make those joint legal decisions to the mother and the mother's particular state of mind, whether it was the result of her mental health issues that she is diagnosed as having, or simply her animosity and hostility towards the father. In any event, she could not make joint legal custodial decisions with the father. The GAL specifically found that the father, by all accounts, was an exemplary parent who was wholly capable and consistently placing the child's needs in front of his own and making appropriate decisions on behalf of the child's best interests. In stark contrast, the GAL found that the mother at times presented as unglued when meeting with the GAL. She found that the mother's allegations against the father were not supported by any evidence. And mother herself admitted that some of the more troubling allegations by mother, for example, that the father had given the child an STD and that the paternal grandmother had sexually abused the child, were not founded, justified, or supported by any of the evidence. And the mother even retracted those allegations to the GAL, which is what started this commodification action, was these very bold, serious allegations. Mother retracted those and said, I don't understand why father thinks I accused him of doing anything wrong. The child's never been abused, and I don't maintain that the child has been abused. The GAL specifically found that the mother's paranoid behaviors included allegations that the father had been stalking the mother, despite the fact that there was a screenshot of the father in his residence at a time when mother insisted he was outside of her house. The mother accused the father of breaking into her bank accounts, breaking into her phone. And these specific allegations are not solely related to father. Mother had this pattern of making allegations against other unrelated third parties as well. But for the purposes of this, these types of allegations are what are stymieing the parties' ability to make joint legal custodial decisions. The GAL report also addressed the DCF findings, which is another area that the court simply disregarded entirely. The DCF report came in as an uncontested exhibit as well, and it needed to be addressed by the court, and it wasn't. DCF itself made findings that they had concerns about mother's grounding to reality and her mental health issues as it related to her ability to parent their child.
Counsel, with respect, I mean, first of all, on physical custody, your client essentially prevailed.
Yes.
And there was limited amount of visitation. There was the issue of supervision, and the judge specifically found there didn't need to be supervised visitation here. And while acknowledging the mother's issues, said it, did not put the child at risk. So you're not challenging that. It's really with regard to the legal custody.
Correct. We're not challenging the physical custody. In fact, the parties had stipulated that the supervision could be unsupervised. And at the time, mother was living in her parents' home and they were providing a significant amount of care. But the issue is really their ability to come together to make these joint legal custodial decisions. And that ties into the second area, Your Honors, where the parties have been unable to reach joint decisions concerning the child's schooling and the child's medical providers. At one point in time, when the child was a younger elementary school, I believe she was kindergarten at the time, the mother threatened the father and extorted money from him to keep her in the same school that she had been enrolled in. Father had to pay her additional money and on top of child support to get the mother to back off of her threats to re-enroll the child in a different school system. When the child was in preschool, unbeknownst to the father, and this is all contained in the GAO reports as well, Your Honor, Your Honors, the mother attempted to unilaterally withdraw the child from preschool, claiming that the child was not being sufficiently socially engaged, which was contradicted by her preschool teachers. When the father purchased a home in Cohasset during the pendencies of his modification action with the view of giving the child a stable home environment and a top-notch school system, the mother refused to allow him to enroll the child, and we needed to seek court intervention and secure a court order for the enrollment in the Cohasset schools. With regards to the child's medical providers, Your Honor, in the GAL report, the GAL spoke to the pediatrician who made similar observations of mother, that she was quote unquote frightening, that she would make excessive demands on his staff by calling the office repeatedly and keeping staff on the phone for extended periods of time, by insisting that the child was sick or was showing signs or symptoms which were not apparent to the physicians, and insisted that the child, and this is probably most troubling, be lead tested when she had no signs of having lead poisoning. And then when the test results came back as normal, the mother didn't believe the test results. The mother has accused the pediatrician's office of stealing her cell phone, which required the pediatrician's office to divert their efforts to look for this supposedly stolen cell phone. Then when the father suggested to the mother that they change the child's dentist because the dentist was down in Bourne and it was geographically inconvenient for both of the parties who live on the South Shore, the mother refused unless they changed the pediatrician, claiming that the pediatrician was biased against her. And again, the GAO report also noted those allegations and supported them. The third area that the court simply glossed over, Your Honor, is the impact of the mother's paranoid behaviors and her direct hostility towards the father. The initial actions were initiated by the mother, who in her own pleadings claimed that the parties had a continued inability to get along and communicate. She did not back off of that, Your Honor. She continued to maintain that. Mother testified at trial that they had interpersonal conflict that at times was quote unquote strong. Mother's counsel represented at trial that the mother had hostility towards the father. All of those things, that hostility, the animosity, the inability, the mother's apparent detachedness from reality at times, we're not suggesting that she presents like that all the time. She certainly does not. There are periods when the parties have been able to co-parent, but those periods are very short and they're very rare. Mother's hostility towards the father extends to her sending repeated text messages to the father, making all sorts of threats and allegations, including she's going to come after him and his family members. She's had 13 or 14 different email addresses. She changes her phone number frequently. She's moved several times in a very short period of time. She blocks father from communicating with her at times. All of these things, when taken as a whole, make it exceptionally, if not impossible, for the parties to co-parent. And in a situation where one parent has been the primary parent for the child, as the father has been in this case, and has successfully been the primary parent, as the father has in this case, there's a very strong suggestion that in a situation where the parties cannot come together and make mutual decisions that are in the best interest of the child, that that primary parent retains sole legal custodial status.
Counsel, what's your best case for the proposition that when a judge rejects findings from a GAL, he or she has to do so explicitly and with findings?
Well, I think it ties into the judge's responsibility to take into account all of the evidence and weigh all of the factors that present itself at trial. The GAL report was uncontested. The DCF report was uncontested. The 50+ text messages that the mother sent to the father making threats to him were uncontested. You know, the acknowledgement that the mother in her own pleading says they have an inability to communicate and get along was uncontested. So I think the responsibility falls on the court to evaluate that evidence in its entirety rather than doing what the lower court did here, which is make one simple sentence acknowledging that the GAL report came in as an uncontested fact, but otherwise wholly ignoring it. And because of that,
the GAL, I mean, the court does comment about the GAL when it's talking about the mother's parenting time, and whether it's supervised or not. The court clearly seems to take out of the report the mental health aspects of the mother, and the court acknowledges that. But we're still left with the court not crediting the father's testimony regarding the inability to co-parent, and the finding that the father has controlling issues or issues regarding control. So you're asking us to focus on things. I mean, it appears as though the court doesn't give it the same weight that you want us to give it.
Well, I think the issue is that the finding that the father is controlling, again, it's a one-line finding and it's not supported by any other evidence other than that he kept a log of mother's parenting time, which when she's canceling with the frequency that she was canceling and or changing the schedule with the frequency she was changing it makes sense, because otherwise there would have been no way to track that or keep account of it. And father's testimony was, in fact, when it started as a joke, because when he would say to the mother, look, if anyone was as sick as frequently as you are, like, I don't know anybody else who does that. And they joked about it. And I don't see that as an issue of control. Similarly, where the court makes a finding that because the father extended the invitation to go trick-or-treating together, that they therefore have the ability to get along and communicate, I suggest that that's wholly insufficient when we're talking about the ability to make joint legal custodial decisions in the face of all of this other uncontested evidence that we had in this case. Again, the mother's psychologist is who the court seems to have credited with the mental health issues. And the psychologist who said, I did not review complete records of mother. I did not know about all of her allegations against father. I did not know about the numerous other allegations she made against third parties, which were of similar relationship to paranoia and a detachment from reality. And the psychologist candidly testified if he had that information, it might have changed his view and perspective on the mother's diagnoses and or her ability to co-parent with the father. And I think that's really where the lower court fell down, Your Honors.
But counsel, why? As I remember this case, there was testimony from Madden, the visitation coordinator, who testified that the parties did have an ability to get along. Why didn't that alone support the judge's finding, rejecting the father's argument that the parents were unable to co-parent?
Because the supervisor also found that the father was incredibly accommodating of the mother. And in fact, when mother wanted to terminate her parenting time, father said, no, I don't want her to terminate that parenting time. And I think the fact that the parties can, for a 1-minute exchange, be pleasant to each other does not mean that they then have the ability to make decisions as supported by the evidence concerning the child's medical care, her enrollment in school, and ongoing communications that they're required to make to share joint legal custody. If there are no other questions, I see my time is almost up, so I'll say thank you.
Seeing none from my colleagues, we will hear from Attorney Curhan.
Good afternoon. May it please the court, Dana Curhan for the mother. Let me start out with the GAL report. My sister just argued that the judge made an error by not considering it. That argument is not actually in her brief or reply brief. I think it's being raised for the first time at oral argument, but I will also say that when you look at the court's decision in the rationale, the GAL report is referenced several times, so it's very clear that the court did consider and accepted portions of the GAL's recommendations, and I assume did not accept others. But turning to the case as a whole, I think this is a fairly simple case to decide. The question is whether the judge could find as a fact that the mother is fit to have shared legal custody, or whether the judge was compelled for some reason as a matter of law to find that she was not. And I think each of the judge's findings in this regard is supported by the evidence. There really are two main...
Counsel, before you go further, though, you've set it up that way, that either has to be as a matter of law or not. Isn't there a middle ground where one, in an ideal world at least, one would like to see what the judge did in terms of wrestling with the contrary conclusions of the GAL and the other evidence that strongly suggested an inability to co-parent. So it's not just the facts not clearly erroneous or as a matter of law, they can't co-parent, but sending it back for more findings that wrestled with some of these issues.
I think the judge did wrestle with these issues. When you look at the GAL report, the GAL sort of didn't make a recommendation or said, here are your options. If you're going to do, the judge essentially said, or the GAL essentially said, if you're going to award the father legal custody, that's fine. If you're going to award the mother, if you're going to award joint legal custody, maybe a parenting coordinator would be a good idea. Now, I guess the judge, the GAL essentially, who was supposed to testify but didn't, the GAL did not actually make a recommendation one way or the other. The GAL made some findings and made some general recommendations, but did not ultimately make a determination on this ultimate issue that we're discussing now. The judge heard a lot of evidence from a lot of people, and the focus was really on two aspects. Number one, was there too much hostility where the mother's joint legal custody just wasn't viable? And number two, her mental health issues. As to the hostility, the judge made a finding based on the testimony of a lot of both parties and several witnesses that the father had exaggerated the level of hostility between them. And I think that finding is supported by the evidence. If you Grace Madden, the parenting the supervisor, said that the parties were cordial and respectful in the presence of the child. The father's mother described her relationship with the mother as cordial. The parties trick-or-treated together for 2 years. They spent Christmas together. The parties made various decisions together on behalf of the child. So I think when you get down to it, the hostility issue, maybe it would have an issue on physical custody, but as far as joint legal custody, I think the father was entitled, or the judge was entitled to find that the mother could handle joint legal custody and that it was appropriate. There is the Miracle Grow incident, which I think really demonstrates the decision-making on the part of both parties, where the father did not tell the mother that the child had ingested Miracle-Gro, and she found out about it when the pediatrician called her. And the father never followed up with the pediatrician. Is this a situation where this evidence is so overwhelming that she can't handle making any decisions on behalf of the child, where the judge should have terminated joint legal custody? I mean, I don't think so. As far as her mental health issues, this was, again, contested evidence. There's no evidence that her issues impaired her in any way in parenting this child. There is evidence to the contrary that any issues that she may have had did not impair her parenting. And this, again, her mother's mother testified that she was a wonderful mother. The parenting supervisor said that she saw no issues that would give her any concern.
How about the testimony of the child's treating physician?
The child's treating physician did not I don't believe testified.
Maybe I got it wrong, Dr. Wong?
Yeah, I think that my memory is that there may have been some statements from her, but I don't believe she testified.
Well, in any event, the references to mother's behavior as delusional and frightening does give one pause, does it not?
Right, but that was all in front of the judge. So the judge had some people who were saying father is wonderful and everything about him is wonderful, and there were some people saying mother is wonderful, and the truth may be somewhere in the middle. And the judge was, this is a case where mother originally had physical custody and mother lost physical custody. Now, the only question is whether mother is capable of having joint legal custody. And the judge heard a lot of evidence on both sides, a lot of contested evidence, and made a decision. And I think that decision on the facts before the judge and the testimony and the documentary evidence was entirely appropriate. If there are concerns that mother has gone off the deep end and that her condition is placing the child in danger, which so far there has not been any concern in that regard, but father has joint legal custody, he can take steps to protect her. But I don't think, I think the judge heard the evidence and made a decision, and it was an entirely appropriate decision. There are a couple of other points that mother raises, the fact that she's moved around a lot and she's changed her phone numbers. I think that is sort of borders on saying the party with the least money really shouldn't have decision-making ability. And, I think she's never been homeless. She's now living with her parents. So there's no issue as to any potential harm to this child. And so that shouldn't even be a factor. And, the judge, it really wasn't an important consideration for the judge. So again, when you look at the issues before the judge, it all comes down to findings of fact. And the question is, are the judge's findings supported by the evidence? And our contention is that they are. Unless there are any additional questions, I'll leave the remaining points for the brief.
Seeing none, thank you both very much.
Case is now being recorded.
Thank you very much. We are here for the sixth and last case of the day. It is 2020 P425 Ann Booth versus Raymond Booth. Two things. One, the case is partially impounded, I assume, because of the financial information, to the extent we can avoid some of the detail on that, that would be useful. Beyond that, I want to remind the parties that we have read the brief, so we're familiar with both the facts and the legal arguments. So I would urge you both to cut to the chase to the extent possible. And with that, I will turn the floor over to Attorney Bagdis.
Thank you, Associate Justices. May it please the court, Catherine Bagdis representing Ann Booth, the appellant in this matter. The statute states that a pension is an asset that's subject to division. Taking a pension and treating it as an income stream is something that the case law permits us to do if there's facts that support that. When you take an asset and turn it into an income stream, it's analogous to taking income property, such as a rental property, and saying, husband's going to be able to retain his interest in this real estate, and he's only going to have to pay wife 20% of the net rental income. It's only appropriate if it's equitable when you look at all the facts in the case.
No, but counsel, doesn't that just simply go to the fact that your two arguments are related? In that, for example, if the judge had treated it as an income stream, as was done here, but had simply divided it from your client's perspective more equitably, then it wouldn't be an issue that it was treated as an income stream as opposed to an asset.
No, Your Honor. The difference here is that when you treat it as an income stream, there's a couple things that happen. First of all, it decreases what the ex-spouse is entitled to. So if you're looking at it as an asset, when you apply the 208-34 factors, they can receive 50%, more than 50%, again, based on what's equitable. When you're looking at it as an income stream and you're applying the alimony statute to it or the Alimony Reform Act, you're limiting how much can actually be paid to the ex-spouse to 35%. And you're placing contingencies on it, where this person isn't allowed to remarry or cohabitate. So you're not only changing the division of it, as you implied, Your Honor, what you're doing is you're changing how it's treated and what potentially can happen to it down the road and limiting this ex-spouse's ability to do other things in her life, because now it's looked at as alimony because it's an income stream instead of treating it as an asset that's subject to division.
Yeah, I'm going to ask a question that shows my ignorance of how these things work in practice, but here the pension was already in payout mode. And I understand that doesn't preclude it's being treated as an asset, but what would that mean in practice? Say the judge had ordered it treated as an asset that had to be divided among the parties after it what was in payout mode. How does that work in practice?
So, Your Honor, it would be divided just as it would be if it hadn't been in payout mode. As far as the practicality of it, you do a qualified domestic relations order, it would be divided. Practically speaking, when you look at it that way, if it were divided the way that we would have suggested as an asset, potentially a 50-50 division or somewhere along that, it obviously would have changed the income that the parties had. Which means that in that case, wife potentially would have had to pay husband alimony for a period of time until she reached a certain age of retirement or things had changed in the future. But again, Your Honors, that brings us back to another issue, which is the uncertainty that the court relies upon in here when it looks at the Andrews case and says, well, in Andrews, the court said that there was uncertainty, and because of that, we're able to treat it as an income stream instead of as an asset to be divided. The uncertainty that the court looked at in this case is common things that every party that goes through a divorce face. They're common post-divorce issues that come up. Somebody's going to retire. Somebody may lose their job. Somebody may change their job. And there's a mechanism in place for the trial court to address that as a later date, because alimony is always modifiable. So you can file a complaint for modification and address those circumstances if and when they come up. But it certainly isn't an uncertainty that would be synonymous to the facts that we saw in Andrews, where an individual had significant health issues going on that precluded her from working, that we didn't know what her needs would be going forward if her health were to get worse and she needed additional assistance, or her health were to get better and potentially she wouldn't need as much support. The other difference that we had in Andrews, where there was this uncertainty that the court appeared to rely upon in our case, is that there were other significant assets for the court to divide. Because anytime, and the court brought this up in the Casey case, anytime that the court is to treat a pension as an income stream instead of treating it as an asset to be divided, there needs to be some sort of compensation to the spouse that's not getting an interest in that pension because it's being treated as an income stream. In the Andrews case, there was $800,000 of other assets to be divided, of which the court gave wife 65% of those. Wife was compensated for husband being able to retain 100% of his interest in the pension. In this case, there were two assets that the parties had. They had equity in the marital home and this pension. When you look at the equity, it was moderate. I mean, modest, very modest, Your Honor. And again, I won't get into figures because you have it before you, but we're not talking about hundreds of thousands of dollars. And that was already determined to be divided equally between the parties. So there were no other assets available to compensate wife to allow husband to be able to retain 100% of the interest in that pension.
Could the judge take into account the wife's likely inheritance of her mother's house?
Your Honor, there was no evidence about wife having inheritance from her mother. So I'm not sure what the court's referring to. I do want to address.
I mean, the mother was living with her elderly mother, taking care of her in the mother's house.
No, Your Honor, the mother, the elderly mother, was living in the marital residence with wife. And that house was the house that was subject to division. So there, and Your Honor, just so the court is aware, I did not file a motion on this, but when you look at appellee's brief, there's a lot of facts that are cited to referring to a transcript, which is not before this court and shouldn't properly be before the court. So all the references in the fact section to a transcript should not be considered by this court, where it does talk somewhat about some assets that mother had, very nominal, and again, would not be something that, in my opinion, or really factually, would be something the court can rely upon as an equitable disbursement because wife had some sort of significant inheritance that may come to her down the road.
Okay, counsel, I may have been wrong on that one, but the wife does have survivorship interests in the pension. And the husband is a fair number of years older than wife. Could this be taken into account given that, in the unfortunate possibility that the husband would pass in the short term, the wife would get her share of the pension at that point?
Your Honor, that's not an appropriate way to look at it because the option C is a contingent benefit that wife has. So the only way she benefits is if husband dies. So despite there being an age difference, there was nothing that indicated that he was on his deathbed, that he had major health issues, and wife, who contributed 35 years to this marriage with the expectation that her and her husband were both going to benefit from this pension, had that taken away from her. And now, yes, there's an option C benefit where if and when he dies, she'll then be able to benefit from it. That's not an equitable way to look at it. And certainly, Your Honor, there was evidence that showed what husband's monthly benefit was decreased by taking the option C. And that certainly is something that the court could consider and what would have been an appropriate division of that as an asset. So maybe not a 50-50 division, but maybe a 45-65, 45-55 division, Your Honor, because of the $122 difference or something along, I think it was $200 difference in the monthly benefit because he took option C instead of taking option A. But there certainly was facts for the court to consider there, but to say that that's a reason that the court shouldn't divide it and instead it should be looked at as an income stream, Your Honor, it's not equitable. The only way wife receives that benefit is if husband were to die.
Does the fact that it was treated as an income stream at this point prevent it from ever being divided as an asset in the future?
Yes, Your Honor. When the court made the finding that it was an income stream and not an asset, that determined what the assets were at the time of divorce, which is non-modifiable. Asset division survives. It can never be looked at by the court again. You can't come in later and say, we're going to ask the court to relook at this and now change its finding that this was an income stream and say that it's now an asset. So that is a definite determination that can't be relooked at by the court.
So the only thing that can happen is maybe an adjustment in the amount of income to alimony to the wife.
Correct, Your Honor. And again, we're limited to 35%, where otherwise she could have had significantly more when you apply the 208-34 factors.
Is that a hard number in the statute, or can that be exceeded with findings?
really, when you read the statute, it appears as though you're capped at 35% as the max, or a person's need not to exceed 35%. So 35 really is a hard and fast rule. It can't go over that, which again is why it's so much to the detriment of the wife in this case. And the bigger issue is if the appeals court in this case were to consider that it is appropriate to look at the potential changes in the party's financial situation, retirement, changing jobs, losing jobs, as an uncertainty that the court can consider as to whether or not we should say this is going to be an income stream or it's going to be an asset to be divided, that's really concerning, because what you're doing is you're giving all the trial courts the opportunity to say, in almost every single case, I'm going to treat it as an income stream. I'm going to take an asset that otherwise I could give 50% or more to the spouse that is going to not be the owner of the pension, and I'm going to reduce it to 35% at the most, and I'm going to put contingencies on it that says that the person can never cohabitate, never get remarried, basically never move on in their personal life if they want to continue to have any interest in that. That is not equitable.
To be precise, it's not 35% of the asset, it's 35% of the difference between their respective incomes, correct?
Correct, Your Honor. So for instance, if you look at the brief I filed, if you look at the income that's the husband's pension versus the other income he has coming in, it actually means that my client is getting less than 10% of the pension benefit that he's getting each month when you do the math that I have in the briefs that I filed with the court.
Okay, if let's just say hypothetically we were to disagree with you that the judge did not have discretion in treating it as an income stream. With that assumption in place, how did the judge abuse her discretion in setting the amount at 20% instead of a higher amount based either on need or on the long marriage and the percentage allowed under the statute?
Certainly, Your Honor. So again, if the court were inclined to say that the court was perfectly fine with treating it as income and not treating it as an asset, and we look at the issue of the award of alimony, again, I'm going to analogize it to if this pension were a piece of real estate that was income producing. You basically took that and said, husband's going to keep 100% of the interest in it, and he's only going to have to pay her 20% of the net income off of that. That is not equitable after 35 years. When you look at this, Your Honors, the 208-34 factors, the most significant factor in this case is the length of the marriage, a 35-year marriage. The court tried to place the most significance on the uncertainty of the potential financial changes that may happen, something that isn't even a 208-34 factor in making this determination. When you go and look at her treating it as an income, and then you look at how the court only gave wife 20%, the court made a finding that the parties are not able to maintain the same marital lifestyle that they had during the marriage because there's not enough income to go around. Yet what the court did in giving wife 20% and not giving her the max that she potentially could is she basically limited wife to say, I'm only going to go by your financial statement. I'll only look at your needs. And I'm going to say that that's what's appropriate instead of giving you more of this asset that I just gave to your husband. There's nothing equitable about the whole picture when you look at it with respect to how the limited assets were divided and then what she's done with the limited income that the parties have. Wife's standard of living is significantly decreased compared to what husband's standard of living was when you look at the financial statements, what their needs were and what was being paid. So, Your Honors, at this point, if you have no other questions, I will forego the remaining time I have because I think I've made the points I wanted to here, and I'm going to rely upon the other arguments that I have in my brief.
You just a minute ago said the judge specifically found that the assets could not maintain the parties in the same lifestyle, or words to that effect. There seemed to be some inconsistencies in what the judge found at different parts of her explanation, because at another point she does seem to say that there is enough to maintain the wife in the lifestyle.
Well, I think what she says is that there's enough assets for husband to be able to provide support to wife so that she can maintain a higher standard than what she has. I do know what you're referring to, Your Honor, but I think that that's what the court was saying. Because in order for the court to order alimony, there has to be a finding that somebody needs it and that also that the other party has the ability to pay it. So I think that that's what the court was trying to put when she made those findings of fact, but I don't think that it was, I don't believe that what she was saying at all was that either party was going to be able to maintain the same standard of living that they had during the marriage, because she made the specific finding that there just were there was not enough income to go around to be able to do that. And again, the case law suggests that when that's the case, both parties' standard of living is supposed to be reduced. And again, with the award that we saw with husband retaining 100% interest, it wasn't done.
Okay, thank you, counsel. We'll hear from Mr. Gallagher.
May it please the court, Sean Gallagher on behalf of Raymond Booth. First to address whether or not it was within the court's broad discretion to treat the pension as an income stream, I'd submit it certainly was. There's Andrews that did it, and then I cite 5 other cases, Duckett and Featherly and Crete, and there's another one in there as well, Pernerick. And in Andrews, that was done because of uncertainty in the financial future. And in this case, there's uncertainty in the financial future in the very near term of both husband and wife. The wife was the primary caretaker of her mother. That was her primary source of income. Her mother was 82 and in failing health. So that was a near-term consideration as it goes to the uncertainty in the income. With respect to husband.
Counsel, why isn't your sister correct that the kinds of uncertainty the judge was speaking of, you're going to have in any such case, especially after a long marriage?
Well, the uncertainty was going to come to fruition very shortly. There's really no doubt on that when you look at the health of the mother. And that would mean when that came to fruition, the financial circumstances of the wife would change tremendously. And it's also true on the part of the husband. The testimony, he was a near certainty that he would not be doing details anymore. And he would be losing approximately 17 or 18% of his income because of that. Sister counsel suggested because of the award in general in Andrews, that was one of the reasons why that they treated it as income stream. But in reading the case, that's not so. The court did not connect the two. And as far as the generosity of the award to the wife, all the court said was it was not inadequate. Now, sister counsel says Casey is the case that you should look at. And in that case, they said that it was error to treat it as an income stream. But the differences between Casey and our case are stark. The main difference being, or one of the differences, in Casey, the trial court attributed income to the wife. The appellate court said that was error. The trial court did not have any alimony provided to the wife. The appellate court said that was error. There was also error in determining the amount of child support. So what that was in Casey, it wasn't so much that it was treated as income stream and not a marital asset. It was the award as a whole was unfair. And that was revisited by the court in Pernerick. And that's exactly what the court said in Pernerick. It was that the award was palpably unfair. So I'd submit that Casey doesn't help the appellant, and Andrews certainly does help the appellee.
But counsel, for the moment, putting aside the fine points of whether this case is more like that case or more like this case, 35 years is a very long marriage. And the main asset at issue here is the pension of your client. And the judge stated a bunch of factors and then just said, okay, I choose 20% in terms of the difference between the wife's expected income and the husband's. 20% in this context seems a little low, speaking only for myself. How did the judge arrive at that, and how can that be sustained in the context of a marriage this long?
That's, of course, certainly a critical point. But kind of on the flip side, he had attained full retirement age. So presumptively, he didn't have to provide any alimony. But the court, for good cause, found that he should. And on the 20%.
Well, if you use Ms. Bagdas's calculations, 9%, 9 point something percent of the pension is what she's receiving.
Well, my calculations would be more than that, but I think that's a little bit off point because it's the full context of the financial factors that determine whether or not it was within the discretion of the court or not, the trial court. And I think when all the numbers are gone through on what he is providing her and what he is losing, the numbers come very close at the end, even when it's 20%. She has her own income. She has a contribution from her mother.
Could I ask you about the contribution from the mother? How does that come into factor?
In Converse, they said that a contribution by a household member would be considered as part of gross income.
So the $175 a week that she pays is what you're considering, correct?
That's right.
Okay.
And you put that in addition with what she's making in total income, and then you add the 122, you get a figure.
Why wouldn't it have been fairer to divide all the assets and then have the wife pay the husband alimony?
I don't know if it would have been fairer, but it might have been within the discretion of the court to do it that way. But that doesn't mean it was outside of the discretion of the court to do it this way. Obviously, there's a wide range of reasonable alternatives. And Justice Milkey's first question was kind of interesting to me, to Ms. Bagdas, because even if it was treated as a marital asset to be equitably divided, there's no valuation of it in this case. And there's no way of knowing how the court would have divided it. There's no way of knowing whether or not the wife would be better off by that route or better off by the route that the judge took, as I see it, as I was thinking about it. So I just put that out there. And I think the judge—
Counsel, before you leave that point, you're correct, obviously, that we don't know for a fact what percentage the judge would have applied, but isn't it fair to say that in any division of a marriage like this, especially a long-term one, you sort of, in your mind, start at 50-50 and then go from there, but you're not going to deviate too far from that number?
I can agree with that. But when you start with 50-50 in these financial circumstances, at the time of trial, the wife had income and the husband had the pension and a modest income of $250 a week. So if that pension were divided 50-50, the wife would be in a much, much better position because of her income already. And
so she would likely be paying alimony.
I think that's probably what would have happened and should have happened. But again, I can't say that because that route could have been taken, that the route taken by the court was outside of what would be reasonable. Abuse of discretion, is it capricious? Is it on a whim? Is it arbitrary? Is it idiosyncratic? And I don't think any of those come close to describing what the judge did in this case. So I thought it fell well within her discretion. And again, that alimony would be worked out. So you don't know. You don't know whether one would be better than the other. So I think the question boils down to is what was done within the discretion of the court. And
I don't know if you can answer this, but if the pension had been divided as an asset, would it theoretically separate out to like two pensions, one for him, one for her? And then, do you understand what I mean?
I do. I do.
Do you know if that's what happens, or do they just take the check and cut two checks? And
my understanding, and it didn't really fall within this case, although it was touched upon, I think there would be an expert evaluation of the pension and what the lump sum total was, and then they'd make a determination as to how to divide that total. And
if she got theoretically 50% at that point, whereas upon his death, she'd get something like 2/3 of it.
2/3, yes.
So it might be better. I mean, but that didn't come into play. I don't mean to.
I don't think it would be like.
I get trouble when I start doing too much math, so we'll leave it at that.
I found a lot of math to be done in this case. So I truly believe the case law is on my side. I think when the numbers are really thoroughly studied, the difference between what the wife receives and what the husband receives is not great. And, he didn't argue about not paying alimony. He went with the 2/3 option for the wife, and that cost him $121. Tremendously frugal. The husband, he has debt of $1,850 he owes on a truck. No other debt. I think the court found, and maybe it wasn't as clear as it should have been, that neither of these two parties would be able to maintain the lifestyle that they had when they were married. And they both had to share there has to be a shared sacrifice in this. And it boiled down to that each party would have to maintain their own residence. And that's why neither one of them could enjoy the lifestyle that they had before the divorce. I don't know if I have much to add to that, but if the court has any other questions.
Well, could you address your sister's argument that in your brief you cite to a lot of evidence that is not currently before us?
Candidly, I'll just apologize to the court, and just be candid. I don't do divorce appeals. I do criminal appeals, and the trial transcript is always there. Always, every single case in a criminal appeal, the trial transcript is there. So I made the wrong assumption that the court would have the transcript. So clearly, I would agree with my sister. If it shouldn't be there, absolutely pay no attention to it.
Okay. Do either of my colleagues have any questions? Oh. Seeing none, we thank you both very much, and the case is now submitted, and that concludes today's sitting. Our appreciation to the clerk for his role in making this Zoom hearing happen. Thank you.